into the microphone so that we can hear you. And those of you on the board, you've got to really speak directly in front of it for us to be able to hear. Thank you.
Okay, it's 9:01. We're going to get started. Good morning. Welcome to the September State Board of Education meeting. I appreciate so many of you coming here today and sharing your time with us. We will start with a moment of silence. Thank you very much. Generally, the best part of our agenda always happens first. It's awesome to see students in the crowd today. We're excited to celebrate you and learn more about your accomplishments. So first up, we have the Russellville High School National Championship Quiz Bowl team. It's my understanding this is the first time to have that. Congratulations and welcome.
Good morning. Thank you, Dr. Moore. So this is exciting to celebrate some young scholars who are out here with us today. And I was talking to a few of them ahead of time, and we actually are able to secure a 3-round lightning round between the team and Mr. Wood this morning. And that's
Let's go.
just kidding, but we're excited about their accomplishments and how they had to win locally and then regionally and then nationally many different rounds. And I think it would be a nice honor, and I don't know if y'all have a captain, but if we can invite the team up to the podium. I know their coach is here. He's first time head coach of the team too. They come up and talk about their journey and introduce the team and give us a chance to learn about the bright futures of these young scholars that we have here with us today.
Very happy to do that. Team members include Will Stump, Ian Warnick, Keegan Fuller, Alex Dunaway, Logan Greggs, Matthew Fox, and Gideon Fuller. We have assistant coaches back there is Andrew Taylor, Rebecca Close.
I think you stopped it.
And I'm Stephen Close, the coach. Just to give you a little information about the tournament they played in, it was in 4 regions. There was a site in Washington, D.C., a site in Chicago, a site in New Orleans, and then there was a virtual tournament as well. And the winners of those 4 regions moved on to a virtual finals where they beat teams from New York, Texas. Little Rock Central was there. One of the biggest challenges we have every year is Little Rock Central. They're one of our big rivals. We love playing them. We beat a team from Dubai International High School, and they ended up beating a team out of Pennsylvania for the title. They were the #1 national seed overall. Their average margin of victory is close to 150 points, which is kind of a blowout for most Quiz Bowl games. So they were very impressive. We were very, very happy, obviously. We had been in that tournament repeatedly. Had always done well in the regionals, but never made it very far at nationals. So we were extremely excited. For the most part, they're all coming back. The scary thing for the other teams around the state is that they're all sophomores last year, so most of them are juniors. We only have 1 senior that graduated, and we have 1 junior that moved up who's a senior this year. So the core of the team is still back, and there's a chance they could repeat again this year. Hopefully they can do that, and maybe we can come back again next year and see y'all again. So I want a couple of thank yous to the district of Russellville itself. They are extremely supportive of Quiz Bowl, and it's a really good indication of this faculty and staff of the entire district. The kids come up to the high school, they're ready to play. They've been playing for years, and when they get here, we just keep that going. And they've won state championships. I think they're at 8 in a row now, so they really keep this kind of going for us. There's also another person in the crowd I'd like to recognize as well, is Dr. Paul Gray. He's kind of hiding in the back. He was our coach before, and he really set the foundation for the program. So without his guidance, and I was an assistant coach, and all of us were coaches with Paul, he really got us trained in what we should be doing. So it was a big help for him. Again, big thank you to Dr. McDonald, Mr. Holt, the entire district itself. We could not be as nearly successful without their support and all that they do for us. So we are truly blessed to be at Russellville.
So we're really really proud of your accomplishments. Would any of you like to come up and talk to us a little bit about your journey and what preparation looks like? We'll put you on the spotlight. There's one in every crowd. I know there's one on this team. Or two of you can come up. Give them some moral support. It's a team effort here.
Hello, I'm Will Stump, part of the team. I'm a rising junior, so I was a sophomore last year when we won nationals. Like Mr. Quoes was saying, we have a great program that we start all the way in 5th grade is when the first year we can do Quiz Bowl is. And so starting and then we work our way and get better and better all the way to the high school where we have, he said the junior high won 8 times. Our high school team has also won state 8 times in a row, so we have big expectations when you get there. It's a great program, a lot of fun. New Orleans, we did really good at New Orleans, and that's, for region, like the region to the nationals is really good. You want to go over here? Kind of behind me, huh? But that was really good, and we all felt good about it. Felt we had going into the next stage, we were first seeded, so it was really exciting. And then as the tournament went on, every game we realized we're still winning by a large margin, which is something that we weren't expecting when we went into it. And so every game it got closer, like this is the quarterfinals, or this is the semifinals, and then we finally won, and it was really exciting to do that. It was really cool to be the first Arkansas team to do that as well. Yeah. Great. Thank y'all. You want to speak? Say some words?
I would just like to say I was not expecting to make a speech. So, like Mr. Quo said, most of those people over there are, with the exception of that guy right there, sorry to call you out, were sophomores when we did this. So, like a majority of the team will be coming back next year, which is really nice to have because we won it once. We have pretty good chances of winning it again. And I'd also like to say that even though they're pretty young, they did really good. So it's nice to see that youngins have such a good.
This is our senior right here.
Yeah, I'm the senior, in case you didn't know. Our youngins have a lot of good potential, and it's nice to see that in a team. I'm really confident that they'll be able to take over next year and be really good.
That's amazing. Thank you both for standing up and sharing a little bit more. I'll open the floor for board members. Comments and congratulations to the team.
Well, I do have a question. I mean, you mentioned you started in 5th grade. That's amazing. That's a lot of commitment. So what is your training like? I mean, what do? Do you work together? Yeah. Can you talk a little bit about that?
The training with it, these kids are extremely dedicated. We have practices a couple times a week, but we also leave the Quiz Bowl room open after school where the coaches will sit in there and basically just ask questions that we have on old games and old practice sets and that kind of thing. But the kids are extremely dedicated. They come in there willingly from about 3:15 to 4:30. Used to be kind of a tradition that we won a tournament, you'd give them Monday off, and they started griping that they couldn't come to the Quiz Bowl room on Mondays, so we had to open it back up. But they were that dedicated. They want to be in there. They have all kind of resources they use, like different programs like Quizlet. They play a game called Proto Bowl, probably too much sometimes, which Quiz Bowl online pretty much 24/7, so they're constantly on Proto Bowl. And again, we play each other. Currently right now, we're having our own tournament here in 2 weeks. And since school has started, they've written over 750 questions for the tournament themselves. So a good way to learn information is have to teach it to somebody else, and that's kind of what they do with those questions. So they're really busy, and they do a lot of work. And again, we're really, really proud of them.
That's amazing. I believe we want to get a picture, but first want to recognize Senator Davis here. Thank you for coming to celebrate your team in Russellville High School. Yeah.
the state game, 2:30 something.
It's a big deal in Texas because districts are doing it, especially small districts or districts that can't pay anything. It's very important to compete.
Right, that's kind of what we do. Well, and with salaries, we were way behind, but we were like 12, 15,000 behind Bentonville. All the big schools, and of course we went to it and then they upped the salary cap, but we had very little time, wasted about half of what we usually have here, so. And we, you know, we're not as smart as we part of it, so it's just the most amazing person ever.
That was awesome. I have a lot to learn from them, and it was neat hearing about the teams and other great teams in our state. Speaking of which, now we have Jackson Jones from Little Rock Central High School to present founder of Fostering Friendships.
So for our second spotlight, we have a bright young scholar out of Little Rock Central High School that actually started a nonprofit organization, and we heard about the wonderful work that he's doing on his own, and it kind of inspired all of us here at the department, where we pretty much very quickly said we need to bring in this young man and hear from him and his story and introduce him to the board. So we're excited to bring Jackson up to the podium. If you want to come up and talk a little bit about the wonderful work you're doing.
Well, I'm Jackson. I'm very nervous, so bear with me.
You only had the National Quiz Bowl championship, so no pressure.
Yeah. So Fostering Friendships, it's a 501c3 nonprofit where we just build friendships with foster children. But it's peer-to-peer friendships with foster children to provide fun and joy and give them a friend and a sense of normalcy that they otherwise don't have. And you know, I watched the presidential debate the other night, and one thing that really stuck out to me was something that Vice President Harris said about, as a nation, us needing to protect the people who are most vulnerable. And these children, they have gone through the worst, and they are the most vulnerable, and they need friends, they need people their age to talk to and to just be a kid with. And so me and a couple of my volunteers who aren't here today, we just go out and find ways we can be their friend and be someone they can talk to that's their age. And I've done some research on this. It's there's a lot of benefit that comes when you have a peer-to-peer relationship with someone. You're less anxious, you often do better in school, and you're just overall happier. And the way to do this, the way to make it a peer-to-peer connection, is to bring people together through commonplace, which is like a shared interest or activity. And that's like sports or board games or things. And so we'll go out and we'll play football with them, or we'll show them a card trick, and it's so cool. But yeah.
So what inspired you to create a nonprofit and to start this program initiative?
So my whole life I've been involved with foster care advocacy. My mom is on the board for Centers for Youth and Family. My dad was a worker for the centers, and growing up I volunteered for different foster care organizations like the centers and Project Zero and stuff, and I saw that these kids, they needed people their age to talk to and to have as a friend. And I thought, why can't I do this? Why can't I make this a reality for them?
Good for you. So if someone wants to find out more information about your nonprofit, how do they?
So they can go to our website. It's www.fosteringfriendship.org, or they can visit our Instagram or Facebook page. It's just fostering.friendships. And then there have been a couple of news stories done on it. So I know KARK 7, Channel 7, Channel 4, and Channel 16 have done stories, and they have the story up on their website.
So do you focus on a particular age group?
Yeah, mostly kids under 18, and it's really important that it's peer-to-peer, so all our volunteers are going to be under 18 together, because it's a true like friendship where you both give and you get. So yeah.
What's your biggest financial need?
Just donations that we need. These kids need like sports stuff. Like if it's like we're a lot of the times we'll introduce them to like football or basketball or something, and then they'll be like, oh, like I want to go play that. So we want to be able to provide them with like the equipment they need. So if it's football, they need a helmet, they need ball, they need gloves, and so any donations are appreciated. It is tax deductible. I'm trained to say that, so.
So I love this, and I can't commend you enough for what you've done. I mean, have you seen this done other places? Have you modeled this after anything, or has this all been your own concept?
No, so I haven't seen it. Any other things I've seen similar things, but it's a mentorship thing. So it'll be somebody who's older, and it's what's different about our organization is it's peer-to-peer connections with children, where it's you give and you get, and you have a real relationship, rather than someone who's a mentor who just kind of talks to you, and they're almost considered like superior, and we don't want to do that. It's more about being equal and being on equal ground. But our goal is to spread this around and get chapters around the nation, because these kids need friends, and they need people to talk to who are their age, and they're not getting it. And so yeah, it's just starting though, and we're getting there. But yeah.
Jackson, how many friendships do you think you've formed through this?
I would say probably around 30 right now.
It's impressive.
But yeah.
And it makes all the sense in the world. I mean, yeah. Great job.
Especially as foster kids are usually very transient, are you able to connect people within their own schools? To connect foster students within their own school. Are you able to?
Mostly, I haven't done anything like in school as much yet, but I would say yeah, we're gonna get to that point. Yeah.
That's amazing. Well, thank you for coming to share with us
of
today.
course.
So I also recognize Principal Russo and Dr. Wright, Superintendent, is with us as well. To Principal Russo, I don't know, do you want to say anything about this program and the impact that you're seeing in your school? I'll put you on the spot.
Yeah, that's fine.
Yeah, you're her moral support. You're her buddy.
I would just like to say how proud we are of Jackson and how proud for him we are. I think it's great that with everything else they have to deal with everything else he's dealing with in high school, that he projects himself and comes up with something totally creative to help other children. And I totally get everything you said, by the way, because of course I have seen this every day with kids who are lost. And Central does have all the children from the foster institutions and around our area. So I just look forward to the support that you're going to give those kids as you progress and build your program, because it definitely is needed. And I just think, unfortunately, it is true that children will tend to listen to their peers before they listen to me or other adults in this school. I think they can just continue to have a great impact on the growing up and being successful. So, very proud of you.
We are proud of you. Congratulations. So we'd like to get a picture.
Make sure your mom's muted. She's like, of course I'm not.
Oh, wow, really?
always great, but particularly great today to hear from students across the state doing amazing things. So I'm glad we were able to take the time to do that. We will move on in our agenda. Are there any changes? I don't believe so. Okay. And then I do want to check, Mr. Henderson is joining via Zoom. Mr. Henderson, are you able to hear us and everything? Okay. Well, I can see you. You might be frozen. We'll check. Okay. We'll message and make sure when you have questions, we're able to get to you. And with that, we'll start with the first action item, the Osceola School District requesting a waiver.
Good morning, Stacy Smith, Deputy Commissioner. Osceola School District is requesting a waiver. I believe they were requesting a 3-year waiver for class size, teaching load, and teacher licensure. Folks at the department have reviewed this. We're comfortable with a 1 year, with us sending in a team to directly work with the districts because we feel like we can probably get the numbers down. But we'd like to kind of have some boots on the ground, get in there, really look at the ratios, the class size, what teachers are, what they have, and start getting folks on some pathways. I believe they are on a Zoom for you to be able to ask them some questions and let them do their presentation.
Yes, and let me check really quickly. Do I need to swear in? Okay, yes. So Superintendent Webster, are you able to hear us okay? Are you able to unmute to speak with us this morning? I'm wondering if we're having some issues. Yeah, is everyone muted, perhaps? Thank you for your patience. Is everyone muted, or we don't know? Okay, there we go. Mr. Webster, can you hear us okay?
Yes, I can hear you well.
Thank you so much. Do you have anyone else from your district to be speaking with you?
I'm sorry, I didn't understand the question again.
Do you have anyone else from your district to be speaking with you?
Yes, Ms. Pamela Center is here as well. Ms.
Okay.
Pamela, would you unmute?
I will do the oath, and then you all have 20 minutes to present your presentation. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may begin.
Good morning. Again, this is I'm the interim superintendent of Osceola School District. I'm here to present our request for waiver regarding the class size and teacher load, as well as licensure waiver for some of our teachers. We are seeking this waiver in order to effectively manage our current staffing challenges while maintaining a quality education for our students. Currently, we have 76 employees. 37 of those are fully licensed, 39 are waiver. 5 of those teachers are in the Arkansas Teacher Corps. 2 has recently passed their practice exam, and 3 of those teachers are out of area. We recognize that the need to provide our waiver teachers with the necessary support to ensure their success and eventually get their license. In doing so, we have partnered with the co-op to provide mentoring, ensuring that all waivers and teachers receive guidance from experienced educators. We have led teachers to, we have lead teachers who mentor and support waiver teachers. We are closely monitoring their progress and waivers for teachers to ensure that they are meeting the required necessary to obtain license. Waiver teachers are clearly is on their contract. We stipulate that they must actively work towards their license, and failure to do so may result in non-renewal. as far as recruitment is concerned, we are recruiting positions throughout the state. We're using School Spring, we're using local newspaper, our district website, we're using K-12, JobSpot, along with Frontline. The request waiver for class size and teachers load will allow us temporarily increase the class size beyond the state mandated limit. This flexibility is essential to give the current shortage for full licensed teacher. By allowing large class sizes, we can ensure that all students continue to receive instruction without overwhelming the teacher staff. Our administrators are dedicated to support teachers and manage large class size. Principal will be monitoring classroom environment to ensure teachers are given the necessary resource and support. Additionally, we will continue to work with Crowley Ridge on our lead teachers to ensure that our waivers teachers are progressing to their license journey and managing their classroom. In conclusion, while we continue to recruit qualified teachers, the waiver will allow the flexibility to manage in the current teacher shortage without compromising the quality of education. We are confident that the system that we have in place, and we can provide effective instruction to our students while working towards full staffing our school with licensed teachers. Thank you.
Thank you, Superintendent. We'll start with board member questions. Ms. Rollins, questions for the district?
Yes, good morning. I know you talked about more than 150 students for a teacher, but it doesn't really specify how many more students would be assigned
I'm sorry,
to that teacher.
I didn't hear the question.
The question is, how many more students are you placing with a teacher? You're requesting more than 150 students, but you're not specific as to the number.
The class size, we're right at what we call the state mandated limit, and instead of hiring another full-time teacher for another class load, we will ask for increase in the number of students per teacher.
But you're not specific in the number that you're asking for.
Every class size has a specific number limit, K through 12. We just at that threshold as far as going over without not hiring a particular teacher. That's the number we're requesting an increase.
Okay.
That may be one in one class, that may be two in another class.
Okay. That really concerns me to leave that really open-ended. Can you tell us what 240 tutoring is? I'm not aware of what that is.
I'm sorry, your question is not clear. I can't hardly hear you.
Let's check with audio. Do we know if there's any way we could increase the volume so that they could hear our speaking on Zoom and we could hear?
Okay.
Okay.
Can you tell us what 240 tutoring is? I'm not aware of that term.
Oh, 240 tutoring, Ms. Pamela?
240 tutoring is through Crowley Ridge Co-op. It helps our teachers prepare for the praxis. It gives them practice tests, and we can also monitor how many times they use it and where they are in that process.
Okay. You've got 35 teachers on waivers. What grade levels are those waivers for?
Ms. Pamela, do you have those numbers?
I'm sorry, I didn't hear the question, I'm sorry.
You have 35 teachers on waivers at this time. Can you tell us what grade levels those teachers are serving?
Yes, we have high school, we have middle school, and we have 1st through 4th grade. And then we have 2 at kindergarten.
How are you supporting the teachers that are on waivers?
We are supporting those teachers, again, through a partnership with our co-op. We're also supporting those teachers with lead teachers in our district as well.
Okay, thank you.
Mr. Wood, questions?
What is the total number of teachers in Osceola?
The total number of teachers that we have in our district is 76. The total number of teachers that are licensed that are 37, and the total number of teachers that are on waiver is 39.
39?
39.
Okay.
We are working with the Filipinos at this point. We have hired 2 the other day, and the possibility we'll hire 5 more before January. Fully licensed.
5 more?
Yes.
Going back to the class sizes issue, all I think I've understood from you is kind of a vague reference to you might have 1 over in one class and maybe 2 over in another class. Is that as specific as you can be with regard to the large class sizes waivers that you're requesting? Because that's not very specific.
Ms. Pam, answer that one.
Sorry. You cut out at the end of it.
Yeah, I said that's not very specific.
Really, we're just needing the waiver for maybe like 10 over. To have like maybe 10 more in the state mandated class size.
Okay. I don't love answers like maybe like 10 over and maybe like 10 more. I wish that when these waiver requests were presented that to be a little more firm in understanding what your classroom situation is. But I think that's all.
Did you understand the question, Ms. Pam?
He was cutting out at the end of it. I'm sorry.
That's okay.
Ms. Hunter, questions? Ms. Woods, questions?
Would that 10 be district-wide or that 10 to be individual classroom?
I know for sure the middle school. Specifically for, I believe, 8th grade.
So, I'm sorry,
Yeah,
I did.
Ms. Hunter.
So, I mean, just continuing to follow on that question, is it 10 in a single classroom at any given time? I mean, like, are we actually mushrooming this class size, a single class size for a teacher?
Did you get a question, Ms. Pamela?
No.
Will you repeat the question again? I'm sorry, we just had some difficult.
Well, I'm just really trying to understand where these potential 10 over exists. Is it in a single classroom, a single class period with a single teacher, or is it some other configuration where these 10 over might come into play? If I walk into a classroom at 10 o'clock in the morning, for example, am I going to see 10 additional students in seats with one instructor in front of them?
I just typed that to
It is for the 8th grade class. So there would be one class for every period in 8th grade.
You will have at least 10 students over the regulation size. Ms. Pam?
Yeah, and I think.
Yes.
Ms. Wood, I think you're asking,
Sorry, I know.
Ms. Hunter, we're also having the teacher load. So the teacher load is the total number of students that teacher has. So it's unclear if you could share what the teacher load will be for that 8th grade class.
Thank you.
Did you hear the question, Ms. Pam?
Yes, the teacher load for that 8th grade class, what would that look like?
How does it? Okay. Let me look real quick.
So I'll just make a comment to the board. This process is frustrating. The fact that a district can come to the state board and request a waiver from statutes and rules and not have a cohesive plan is concerning. The student performance at these schools are subpar. They're D's and F's, and I have very concerns that this district has a plan that lacks any sense in moving forward, and to come here and say we want a 3-year waiver of all rules and statutes is something that I would not be in support of. What I am in support of is sending our school improvement team to that school to find out actually what's happening in this school, who is standing in front of these students, and are they able to learn before we grant some kind of magical waiver that just gives them a green light to do whatever they want. I'm not comfortable that this district has a plan. School started. These classrooms should have been staffed. We can't even tell you how many kids are in a classroom. We can't tell you what the teacher loads are. We can't tell you what the qualifications are of teachers that are standing in front of the students. And if I'm hearing over half the teachers are unlicensed, that's not going to be a good outcome for student achievement. And that's what we need to stand behind. We need to be advocates for the students that are in that school, and we need to make sure this district has a cohesive plan before granting any magical waivers.
Board members?
I agree.
Can we second that? Second.
Mr. Henderson, I want to see if you have any questions.
No, I don't. Looks like the secretary did a really good job of explaining the concern. You know, I'm just kind of curious to know where we were able to equate that targeted number of 10. Because it looks like if you don't have the data to support it, it just doesn't look sufficient.
I would also like to hear more about the Opportunity Culture Pilot. Is this pilot no longer in place with them? Because in the written portion, there's a lot of talk about a multi-classroom leader role and all that, but I'm not hearing you all discuss anything like that.
Carly Saraceni, Assistant Commissioner of Educator Effectiveness and Licensure. And yes, in past we have piloted Opportunity Culture Schools. We have a few out there we still support, but as we are transitioning to those master and lead designated teachers, we're kind of going from that model of opportunity culture to that career continuum that any teacher can lead from the classroom and support those novice teachers or those aspiring teachers with really great credentials of that master and lead designation, the coaching training, and all those variables that are very much needed when you're mentoring novice teachers or aspiring teachers.
I appreciate that now on the form, when a district is requesting a waiver, they, in number 4, in all capital letters, it says provide data or evidence to support your answer. And we don't see any data here. And so I think it would be helpful for us to get some data to see what the impact of that program was in order to understand if this is the best way to move forward. And if the district doesn't have the capacity to do that, do you all work with them? Or could you all work with them on looking at that?
Yes, that's why we would like to send our team in, Melissa Jacks. We have a great human capital team to go in and work with them to make sure we're getting everyone on the right path.
I have one additional question. The waiver that they currently hold, do we know when it expires for teacher licensure?
I believe they expired for this year. So they're asking for the waiver for continuation this year. They submitted their paperwork for waiver requests this summer, and so it was put on the agenda for them to look at as it's been going through the process.
Okay. So those teachers are currently employed right now and with no waiver. What's the consequence if this is not approved today?
I think, I mean, I would encourage that we table for today and that we send a team down this month, work with the district and get very clear on what we're requesting. Is it a 150 load for grades, high school grades? Is it a class size for elementary grades? What are we talking about with the 10? How many teachers are actually on pathways versus how many actually need a waiver at the district level? So that would be my suggestion, is we table, send a team down, come back next month and have clarity on what is actually needed, if any.
I was going to make that same suggestion. It is clear that there is not a plan. And I go back to the process that districts can put forth a request to get in front of this board without a plan. And that's something that's frustrating, but allowed. My recommendation is we send a team of folks to help them develop a plan. And at the end of the day, if we don't approve their waiver request and they get a citation, it's still on the district. They should have, they've been on waivers. And this is my concern about just granting magical 3-year waivers, because at the end of 3 years, districts come back and say, we made no progress, we need another 3 years. So there needs to be a sense of urgency, not only from our board, but from leadership in the district. And I think if we can take some time over the next couple of weeks to find out exactly, walk these classrooms, see how many students are in the classrooms, what the teacher loads are, who's teaching what matters, and we'll bring back a better report and a better request, but I would not recommend approving this waiver request at this time.
Is there any problem though with them being not having like a month waiver overlap, I guess is my question.
If they get a sanction, they get a sanction. Okay. I mean, the district knew this was coming. This isn't a new phenomenon. These aren't new rules and new statutes.
Right, and I'm just gonna add one thing to that. So, I mean, plans obviously are super important and we need a plan, but we also need goals, because whether they come with a 1 year or 3 year, whatever the waiver request is, I mean, they just keep coming through. It's like a revolving door, and like we don't have any yardstick measure to know. I mean, we can say, well, they've been working their plan. That's admirable, but are they making progress toward anything? To me, that's a different perspective that I, as a board member, would like to be able to know.
And I would second to that all districts that are coming to us
Correct.
For this waiver.
Yes.
We have districts that typically come out of desperation and aren't able to show any of that, and we need to. Okay. With that, any additional questions or comments, board members?
You need a motion to
To
table it?
deny or to table?
I think you would need a motion.
To table, yes.
All right, I'll move to table it, and I hope that the leadership at Osceola will hear the comments today, be receptive to the department, working with them over the next few weeks, and develop a long-term plan for success for the students there.
There's a motion by Mr. Wood to table action item 1. Is there a second?
I'll second.
A second by Mr. Bragg.
Can I interrupt on my own motion? Does it need a time frame to bring it back, or is it just exist?
I think if you table it, we'll bring it back when it's ready.
Sounds good.
If we don't have a plan that is acceptable from our agency to bring to this board, it's not coming. So Yep, it can be indefinite.
Can I also add that the local school board also signed off on a resolution that really accepts all of these, plus a waiver request to modify recess for the students. And I believe they need also some training as well at the school board, so they understand what they've signed off on.
It's fair.
So we have a motion by Mr. Wood, a second by Mr. Bragg. Any more comments? We'll take a vote. All in favor say aye.
Aye.
Any opposed? Motion passes. Yes. Mr. Webster, thank you for getting on today, and the agency will be in touch with next steps. We look forward to hearing more from you all soon with that work being done. With that, we will move on to action item 2, a request for final approval of rules. We have 2 sets of rules for final approval here.
All right, we've got 2 sets of rules that are coming to the board in their final stages, so they've already been out for public comment. They've already been released by you. They've done public comment. Now they're coming back to you for final approval. One of those is the implementation of Braille and large print textbook appropriation. Again, that's the oversight of providing adaptive text for schools and for school for the blind. The second one was the rules governing public school choice, which we changed. One of the main things on there was removing the cap, clarifying some overlapping school choice legislation pieces. So asking for final approval for those 2 rules today.
Board members, questions on either rule? Ms. Rollins, Mr. Wood, Ms. Hunter? To my right, questions? Mr. Henderson, questions?
No, I do not have any.
Okay. And these, should we take them in separate or together? It doesn't matter, whatever the will is, whoever makes the motion.
Move to approve the DESI rule governing Braille and large textbook appropriation.
There's a motion on the table. Is there a second?
Second.
Okay, a motion by Mr. Wood, a second by Ms. Rollins. Any questions or comments? All in favor say aye.
Aye.
Any opposed? Motion passes. Next, we have the rules governing public school choice.
Move to approve the DESI rules governing public school choice.
A motion by Mr. Wood to approve the rules. Is there a second?
Second.
A second by Ms. Rollins. Any comments or questions? All in favor say aye.
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 Any opposed? The motion passes. Thank you. Next, we have action item 3, a request to release administrative rules for public comment.
Action item 3 should be the first hearing.
Oh. Okay, so I actually had printed out an old agenda.
Well, you'll be happy to know that I printed out an old agenda too, and so I was back there panicking. That item has been removed.
Okay, so action item 3 is now a PLSB standards case.
Yes, ma'am.
Okay,
Thank you.
Thank you. Sorry about the confusion there. Ms. James will come up to present. Thank you.
I printed off a new one and then an old one too.
Good morning. I'm Whitney James with the department. We have 4 of these today. The first hearing that we have is regarding an educator named Dexter Dumas. This is one that went to an evidentiary hearing, and he has rejected that recommendation and asked for a review by the state board. I just wanted to go over the procedures, if I may. Sorry, I've got a big folder of items up here. So in these cases, either the PLSB or the educator may make an oral argument, and I will make an argument, and Mr. Dumas will as well. The first is the PLSB's oral argument. The educator's oral argument for 10 minutes, followed by the PLSB's. And then after that, there can be discussion, questions, whatever you would like to ask of myself, my investigator, or Mr. Dumas. And then it will be time to make a motion and vote on what happens on this case. Are there any questions?
Any questions, board members? Okay, thank you.
All right. And if you will swear in anyone other than the attorneys who is speaking, should be good to go.
So Mr. Dumas, please stand. And do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Absolutely. Thank you. Ms. James, 20 minutes, or is it 5 first?
It's 10 minutes each, and Mr. Dumas goes first.
Okay, thank you.
Good morning. So, December 2022, I was accused of touching a student. I was taken to jail, mugshot, fingerprinted. During that time, I was bailed out of jail. In January 2023, Tish Knowles, the superintendent of Earl School District, put me on leave, as she should. At that time, there was no investigation that was done by the school district. I was recommended for termination. July 2021, the charges was dropped from the county. I went January, February, March, April, back and forth because I live in Dallas, Texas. Showed up all time for court, only to find out in July 2021, the charges was dropped. I rewarded the student by doing something great for him. He was a basketball player. As the principal at the time, I rewarded the student with the consent of his parent. I gave the student $15 for doing great job as an educator do. Student came to my office in December because that's where my money was. I didn't have any cash on me. He was in the hallway. He was a student that had attendance issues while in my office. I reminded him that, look, I'm giving you this award because your dad told me I could do so. I said, but again, your attendance is the issue, and also your academics. Remember here, no pass, no play. He said, well, Mr. Dumas, I understand. I don't do well in science. I said, you don't have to do well in science. You have to pass science. You don't have to like gravy to eat gravy. You have to pass the class. The student went to class, no issue. That's in December. I rewarded the student for doing something well, as a good teacher would do, as a good principal would do. July came around, all charges was dropped. I would ask the board to not suspend my license because I'm a great educator. I close by saying that I remember clearly when I was in the 4th grade, Ms. Jones, my math teacher, rewarded me by giving me an apple. She didn't ask for permission from my parents to do so. She did. I remember when I was in the 7th grade, my home economics teacher gave me the extra slice of cake because I did well in home economics. I like chocolate cake. I did well with that. I got permission from the parent to reward the students. That's what happened with that. I want to maintain my teacher's license because, again, I rewarded the student and all those charges was dropped. I welcome any questions.
Yes, you
Ladies
have
and gentlemen of the board,
5 more minutes.
Pardon?
You have 5 more minutes.
Oh, okay. I won't take that long. Greg Allagood is my name. I'm an attorney here in Little Rock, and I have represented Mr. Dumas in these proceedings. And I just wanted to make sure that everyone understood what I had set forth in my brief, and that is, I was merely suggesting that the PLSB would suspend Mr. Dumas's license for a period of time while he had the opportunity then to conclude this separate avenue that he's pursuing of challenging the DHS true finding of maltreatment. Now, I mean, as we all are gathered here today, Dexter Dumas's name is on the child maltreatment registry. That's indisputable. What I hope you understand from having read the materials and what I tried to point out in my brief is that he has exercised his right under the Administrative Procedures Act to appeal that DHS agency order to Pulaski County Circuit Court, and that is pending. And I reasonably feel like this is going to be concluded before the end of this calendar year. It seemed to me that the basic reason that the PLSB and the hearing panel subsequently were determining that his license should be revoked is because his name is on the maltreatment registry. So all I'm saying is we can accomplish the purpose of temporarily invalidating his teacher's license by keeping him suspended for a period of time to give him the opportunity to go ahead and conclude the challenge that the law affords him to see if he can get that true finding overturned. So, you know, I'm not asking you just to completely repudiate everything that the PLSE did. I don't think that you can do that, but I think we could accomplish the same purpose by simply suspending his license and holding this matter in abeyance while he's given the opportunity to conclude that parallel proceeding that's going on in Pulaski County Circuit Court. Did I make that clear as mud? You're nodding yes.
I would like to add one more thing. John Hoard was a superintendent for the state. He was sent to Earl, Arkansas to assist the superintendent. While waiting on math teachers, he subbed in my classroom. As a superintendent, he would sub in my classroom. John Hoard did the exact same thing. He rewarded the students in terms of academics. He rewarded the students with $25, and God knows I don't have $25 because the state of Arkansas doesn't pay that much, but he rewarded the students. I did the exact same thing that the superintendent did at the time.
Okay, thank you. Now the state has 10 minutes to present.
My name is Whitney James with the department. As you know, Mr. Dexter Dumas was a principal at Earl High School. An allegation was filed with our office stating that Mr. Dumas allegedly pulled a student out of class multiple times on December the 21st of 2022 and inappropriately touched the student while in his office. The student also reported that Mr. Dumas had previously given him drinks, snacks, and monetary rewards for scoring points during basketball games, and I believe that he'll admit to that. When the student reported to his parents that the inappropriate touching happened, his parents filed a police report. Mr. Dumas was arrested, as he said, for second-degree sexual assault. The prosecutor ultimately decided not to pursue the charges. However, that does not mean that the assault did not happen. That also does not mean that you cannot take action against Mr. Dumas's teaching license today. The Crimes Against Children Division also investigated the case, talked with the victim. The victim had a forensic interview. Those interviewers are specifically trained to talk to students who are alleging that they have been sexually abused. And the CACD also reviewed footage from the school cameras, which corroborates the student's version of events, which was that he was called to the office multiple times that day. Mr. Dumas denies, and he denied in his interview with our office, that that happened, but that is not what the investigation revealed, and that's not what the DHS report states. The investigator in that case also reviewed the camera footage. The Crimes Against Children investigator came to our evidentiary hearing and testified. He's a veteran law enforcement officer. He did say that he believed, based on all of his years of experience, that the student's statement of events was credible. As Mr. Dumas said, he is currently on the Child Maltreatment Registry, which means that he had a true finding with DHS following the initial investigation. He appealed that. He had an administrative hearing at which he called witnesses and had the opportunity to present his case, and an administrative law judge upheld the finding of abuse. So he has been through that process. That is why he's on the registry. In his objections and brief, Mr. Dumas states that he is appealing his placement on the Child Maltreatment Registry. That's not really relevant to what's going on today. We are looking at the alleged violation of the Code of Ethics. He has had, like I said, he has had 2 hearings. He's had an evidentiary hearing with us. He's had the DHS hearing, and both the PLSB Ethics Subcommittee and Hearing Subcommittee found that there was a preponderance of the evidence that he violated standards 1 and 2 and that his license should be revoked. Everyone but Dexter Dumas agrees that he should not be around students. Mr. Dumas has requested that the state board suspend his license pending the outcome of his appeal of the DHS finding. There's not really a way to do that through the PLSB process. And we are asking that if you find that there's a preponderance of evidence that he violated the Code of Ethics because he inappropriately touched a student, that his license should be revoked. We are arguing that it should be, and that is what we are asking for today. Thank you so much.
Ms. James, remind me, at this point, questions are open for both sides. Is that correct?
Yes, for my office and for the educator, should you have any. I also have my investigator here, Sarah Banker, who was the investigator on this case, if you have any questions for her.
Thank you.
Thank you.
Board members to my left, Ms. Rollins, questions? Mr. Wood?
To Mr. Dumas, would you mind to describe the factual basis for your appeal to have your name removed from the Child Maltreatment Registry?
May I respond to that since I'm his attorney in that proceeding?
You may.
I
suspect.
It's a two-pronged approach. One is we are claiming that there were some procedural infirmities involved, one of them being there's a DHS rule that requires that the administrative hearing process be resolved within 180 days of the date that it's requested. That did not happen in this case. The other is challenging whether or not, given, as I pointed out in my objections and brief to you, what we consider to be some serious credibility issues with the student and his, might I add, totally uncorroborated allegations directed against Mr. Dumas, that it does not rise to what the Administrative Procedures Act expects in the way of substantial evidence in order to support that agency decision. That's it in a nutshell.
How do you respond to Ms. James' presentation that video evidence does corroborate the students' stories, that they were called to the office several times on the day in question?
I've been at every hearing along the way. I don't remember that. I don't remember seeing any such video. The young man told the law enforcement investigators that he was just absolutely distraught. He went back to his classroom crying. One of the witnesses, both at the DHS proceeding and at the PLSB proceeding, was the teacher who said he came in laughing. Totally contradicts his story about being so distraught, as you would expect a student to be had they just been victimized by a sexual assault. But his demeanor ran totally contrary to his story about how upset he was ostensibly that morning.
That's all.
Ms. Hunter, questions? Mr. Bragg?
So who are you actually appealing to? I'm a little confused on the process here.
I'm sorry, what now?
Who are you actually appealing to right now?
Well, under the Administrative Procedures Act, if an individual is aggrieved by the action of a state board, then they have the right to appeal that to either Pulaski County Circuit Court or the circuit court in the county in which they reside. Well, given the fact, excuse me, that Mr. Dumas currently resides in Texas, the only alternative there was Pulaski County Circuit Court. So that's where I mean, just as Ms. James always, admonishes folks, they've got the right to appeal State Board of Education decisions to Circuit Court under the Administrative Procedures Act, should they feel like they've got a basis under the law to do so.
Ms. Woods, questions?
I just wanted to clarify something. So his felony charge wasn't exactly dismissed, correct?
It was dismissed.
Well, no, because I looked up the case and it was null pros.
It was null pros.
Well, I mean, there's a difference there. I mean,
Well, the time has come and gone, has it not, for it to have been refiled?
I assume I
The
have
null
not checked
pros
the date.
order recites that it was for insufficient evidence.
Okay, but it's not a dismissal. I just want to make sure we're clear on that.
Well, it's a dismissal without prejudice. Is it not?
I'll have to look that back up. I mean, it's just from my notes. But there's a process to dismiss, and then there's null pros for insufficient evidence, because the bar is high. I mean, reasonable doubt is very high in a felony charge. So that's their decision to not do that. I just wanted to make sure we clarified that. Thank you.
Mr. McCaslin, questions? Mr. Henderson, questions?
Yeah, I'm not sure if I caught all of that due to the network, but it's two things, I guess, what I'm seeing here, a code of ethics and also a violation of standard. My question, I'm unsure if Ms. Wood asked the same question. How or why was the charges dismissed? Or are we allowed to ask that question?
Well, one of our exhibits to the PLSB was a copy of the null pros order, which cited that it was being null prossed, which basically means that it's, in my opinion, in my understanding, it's being dismissed subject to the ability to refile it within a one-year period of time. But that order itself cited at the bottom of it that the reason why it was being null prossed was for insufficient evidence.
Did you get that, Mr. Henderson?
Yes, I copied that. Thank you.
Yes, Ms. James.
The CACD investigator at the evidentiary hearing, as you'll see in your transcript, did talk some about his belief about why the case was not pursued. Additionally, he also testified under oath to his opinion of the student's credibility and the video footage. Just to point that out in response to Mr. Allagood's statement.
Okay, may I ask some questions of you?
Yes.
At that point in time, was there the evidence, so the evidence submitted to DHS not once but twice? I mean, the first time put it on the child maltreatment, and then with the appeal left him on the child maltreatment, is that correct?
The investigation led to a true finding, and then he again had an administrative hearing at which he could make all of his arguments, and the administrative law judge upheld the true finding, and his name was placed on the registry, and that was with the testimony of the teacher that he is claiming said the student came back to class and was fine.
Okay, and how long is he on the registry for?
I'm sorry.
How long is he on the registry for?
Well, I think that's the type of charge that you can never have removed if it's ultimately upheld.
Okay.
You know, various levels of maltreatment can be automatically dropped after a year, or you can petition to have them removed after a year. But I believe this would be the category where it's going to stay on there under the DHS rules, absent it's ultimately overturned.
Okay, Mr. Dumas, do you have a license to teach in Texas?
Yes, ma'am.
Okay, if if you want to come to the microphone. Sorry. You have a license to teach in Texas?
I do.
Okay, and so this is consequential for that. Unfortunately, this is my least favorite part of this job. Over my term on the state board, I have seen repeat offenders where we have allowed someone a suspension and then they've come back and repeated the same offense.
Understood.
And so we have to set a bar for what can be allowed for students. I don't know if you could share any more as to the incident with the student and what you believe led the student to make these allegations, and if you've ever had anything else like this happen in your career.
So the only thing I can say to that is, again, I reminded the student that he was failing and he would not be able to play basketball on the next game. When the student left out of my office, he told me that I'm having issues in science. I reminded the student, again, no pass, no play, right? After giving him the reward from the dad who told me I could do so. And so that's the best I can answer, that he was failing and he was not going to be able to participate in the next ball game.
Okay. And so you hold that you did not touch him?
Oh, absolutely not. I did not touch him.
Okay. Board members, additional questions for Mr. Dumas or the state at this point?
I have a question
Sure.
for the state. You mentioned a video. What would the video show us if we saw it today? What evidence is it?
My understanding is that the student stated that Mr. Dumas had called him to the office on several occasions that day. In our interview, when we asked him about that, he maintained that he had only, I think, called him into his office one time and maybe called him back one additional time, but not into the inner office to pick up a gift. The student was picking up a gift from his girlfriend. The CACD investigator testified that the video evidence from the school did show the student being called to the office multiple times, as he stated when he was interviewed in the forensic interview.
But is multiple times 2 times?
I believe it was 3 to 4 times. It was more than, I believe it would have been more than twice. I'll have to go back and look at the transcript. But he did state in his testimony that the video evidence corroborated the student's version of events.
Could there have been a reason for other people in the office to call him?
Not that I'm aware of.
Would you
Ms.
like to speak
James?
to that, Mr. Dumas? Hang on, would you like to speak to that? Or your attorney, either one.
Well, I've never seen that video. The young man also said that there were going to be other students that would corroborate similar occurrences with Mr. Dumas, and there's not a single one. There's absolutely no corroboration that this allegation occurred. Now, I know you have to take the allegation seriously. Everybody does. But it's absolutely uncorroborated. And I don't see what the harm would be in this board suspending Mr. Dumas's license for a period of time while he's given the opportunity to pursue his remedies under the law. That's what we're asking. That's what I'm asking. Thank you.
Ms. James, I, again, have a hard time because, so this has been seen by DHS twice.
Twice.
And it's been seen by 2 PLSB committees.
Yes.
That's correct. And they've all held the same.
Yes, ma'am.
Okay. Board members, further questions?
Mr. Rhodes, did you have something you wanted to say?
Primarily just making myself available, but to your question earlier, there is a legal distinction between nolle prosequi and a dismissal, and that nolle prosequi is really, it's an extension of a prosecutor's ability to choose to prosecute a case or not, right? Whereas a dismissal would be what people normally think of court saying your charges are dismissed because of a number of reasons. So there is a legal distinction, and the prosecutor has chosen not to prosecute. And there was a limited amount of time to refile charges. That time seems to have expired, but that is again going to the prosecutor's discretion, not necessarily the court's full review of the case before it.
My understanding of null process always just been, there may be evidence, but it's not evidence to reach the bar of reasonable doubt, and that's their discretion on whether or not to pursue
Correct.
it. So that's why I say there is a difference between actual dismissal with prejudice or without prejudice and a null pros.
Right.
And so to say that it was dismissed is an inaccurate statement, because it wasn't. That was my only point.
That was it. Just make myself available.
Well, and I hope you don't think that I was trying to mislead you
No.
by my use of terms.
No, and I don't even think you said the word dismissal. I think it was Mr. Dumas. I just wanted to make sure that's clear.
I did want to make one more comment about corroboration. This event allegedly happened with Mr. Dumas and the student alone in Mr. Dumas's office. I don't think it's ever been alleged by anyone that there were other students present. I think it's more of a question of his behavior after the incident. However, as you will see in the hearing transcript, the investigator testified that the mother knew that something was wrong. Her son was in great distress, and she knew. And that's when the student told his parents, law enforcement, the forensic interviewer, that this had occurred, multiple individuals.
Ms. James, may I ask a question at this point? The allegation of that with a student, also coupled with allegation of paying students, is there sanctions against an educator giving students money, in particular around sports?
It could be, yes, ma'am.
Okay, but that wasn't pursued here.
The main, the allegation here was focused on the sexual abuse. Yes, ma'am.
Mr. Henderson wanted to touch base to see if you had any questions. Okay, thank you. Board members, any questions at this point? Okay, so no further questions at this point. The floor is open for comments or motion. And Ms. James, will you remind us of what options would be for a motion?
Yes, ma'am. There will be three, we will need three different motions. First being whether or not Mr. Dumas violated the Code of Ethics and what standards. The second is if the Code of Ethics were violated, accept, modify the recommendations of the hearing panel. Third is the rationale, accept or modify the rationale of the hearing panel.
Thank you. Board members, is anyone prepared for a motion or have questions on how those motions are made? No. This is truly a very difficult part of our job.
I do think it would be helpful in these to have kind of a form motion, not necessarily with the result that the state might be asking for, but just written guidance on what we do, what options we have, so that kind of have that at our disposal.
Sure.
In future
Yes, sir.
hearings. I guess I'll make a comment that Mr. Dumas, I'm going to vote to support the decision of the PLSB. It is not because I'm placing myself in judgment over you. It is that the accusations have been presented to multiple, I'll call it finders of fact, and they have had an extensive review of the evidence, and they have weighed the evidence, and I don't believe that our 10, 20, 30 minutes here is sufficient for us to step in place of those various panels. And so I won't replace my opinions today for their review and their conclusion.
Just so that I make sure I understand, if we do what is suggested by Mr. Dumas, which is to wait for the administrative law hearing to come out, assuming he gets off the maltreatment registry though, can he reapply for his license if we were to revoke today?
The suspension would have to be for a set amount of time, and that's what makes it tricky. I don't know how long that process is going to take. Of course, we're still arguing for revocation because he does still have a valid teaching license in another state.
So to that point, if we adopted the recommendation to suspend today.
Yes, ma'am.
What impact does that have on a license in another state?
It would depend on the laws of that state. I would think that if he is revoked here, then they would likely do the same thing. I'm not totally sure, but I don't know if he's suspended here, if it would, how that would carry over.
So, question about his appeal, what he's appealing to, would it depend on a preponderance of evidence or beyond a reasonable doubt?
Well, actually, under the Administrative Procedures Act, you don't get like a whole new trial. The Administrative Procedures Act sets out the limited instances in which the circuit judge may vacate, reverse, uphold, remand the agency decision. And it could be for a lack of substantial evidence. It could be because it would appear that the agency's decision was arbitrary or capricious or characterized by an abuse of discretion. It could be because they exceeded their regulatory guidelines. My 2 points is that we don't feel like the evidence was substantial, and we do feel like there were some procedural infirmities where DHS failed to adhere to their own regulations.
Just to respond to that somewhat, if you find by a preponderance of the evidence that he inappropriately touched a student, I would argue that the appropriate sanction is not suspension of license. And that's another reason I don't think that waiting on the DHS decision or what the status of that is right now should affect your decision today. That's just my argument.
And, I'm not an attorney, so, and this seems very attorney-ish here. But let's say that the final appeal is successful and it is because of an administrative error. The 180 days was exceeded, that it was truly a clerical error in my terms, and that we had suspended. So now he comes off the child maltreatment. So there's really, then do we have any remedy? Because, frankly, that whole administrative portion is not really in our purview right now. It is really, did he violate the code of ethics, and what is the sanction for that? So it is not about timing and whatnot. Am I understanding that correctly? And I'm asking,
I just want to make sure, basically, if we suspend him today and he gets off on a technicality, I don't think we have any recourse to go back and say, oh, well, now let's revisit this whole thing. We would just be letting him off on a technicality.
Right, so that would be our risk. Okay.
This would close out the PLSB case, whatever your decision is, and the suspension would be for a certain amount of time, so.
And then it would expire and, okay. Thank you.
Yes, ma'am.
Any further comments? Ready to make a motion?
In the motion, do we need to name the code of ethics violations? The previous standards were 1 and 2.
Anyone prepared to make a motion?
I'll make the motion then that Mr. Dumas violated standards 1 and 2.
I'll second that.
There's a motion by Ms. Rollins, a second by Ms. Hunter. Any comments? All in favor say aye.
Aye.
Any opposed? Okay, motion passes. So now the second motion is,
To accept or modify the recommendation of the hearing panel. So I'm going to make a motion to accept the decision of the hearing panel.
I'll second.
okay, there's a motion by Ms. Hunter and a second by Mr. Bragg to accept the hearing panel's decision. Any comments? Okay, all in favor say aye.
Aye.
Any opposed? Okay, motion passes. And then the third motion,
The third motion is to accept or modify the rationale of the hearing panel. I can read that to you if you would like.
okay,
The rationale for the hearing panel, and you can add anything or remove anything that you would like. True finding from DHS, educators on the maltreatment registry, witness investigator Grimes' testimony was compelling and indicated that the student's interview was extremely credible. Educator admitted to giving money to the student. Educator gave student money as an incentive for his performance in a basketball game. And then, let's see, some of this is duplicative. Educator has a true finding from DHS, which was upheld on appeal to the administrative law judge. Student stated that the educator put his hand down his pants and groped his penis to multiple individuals, including the coach, his mom, his dad, and the investigators during the forensic interview. High level of negative impact, as witness investigator Grimes testified that administrative law judge indicated the educator is a vulnerable risk to the public. Educator admitted he gave student gifts and money. Educator admitted he was alone in his office with the student and could not recall if the door was open or shut.
so
I make a motion that we accept the rationale from the hearing panel.
a motion by Ms. Rollins to accept the rationale. Is there a second?
Second.
A second by Ms. Hunter. All in favor say aye.
Aye.
Any opposed? Motion passes. We have 4 cases here, 5. Do we want to take a break now or do one more? We'll proceed on to the next one.
So this is regarding educator Chase Utley. This is a case that was on your consent agenda previously that you voted to remove for a review in place of the next available action agenda. This just happens to be the next one that was available. Mr. Utley's attorney is here. Again, same procedures. The educator may make an oral argument first. He is not present, however, his attorney is here, followed by the PLSB's oral argument. Any questions about the procedures?
Okay, so the educator's not here. Is there anyone speaking on his behalf besides an attorney?
No.
Okay, so I don't need to swear you in. You've been sworn in to the bar. Okay. Okay, so you have 10 minutes.
Pardon?
You have 10 minutes.
Thank you. I'm still Greg Allagood, an attorney here in Little Rock. And in anticipation that his license was going to be suspended, as Mr. Utley had agreed with the decision of the PLSB hearing panel, he took a job in the private business sector. He had made arrangements to be, and that job actually necessitates that he travel out of state frequently. He had made arrangements to be off work for your August meeting, but as it turns out, you held it, I think, in Bentonville after all, and so we agreed that it would be set over to today. He is hopelessly engaged with his immediate supervisor in Birmingham, Alabama today. He had hoped that he could Zoom in, but he begs you not to construe his absence from these proceedings today to be indifference on his part. He fervently hopes that you will uphold the recommendation of the PLSB hearing panel to which he had agreed. Now, I was not at your hearing, your meeting rather in June, but the way Ms. James had represented it to me was you had some concerns about whether or not the PLSB hearing panel had adequately addressed potential negative impact on students. And so that's what I've kind of honed in on in having reviewed the transcript. And if you had an opportunity to review the transcript, several places it's described that the young lady became uncomfortable with the volume of text messages that were taking place with the teacher. And her mother had testified, and I can point you to page and line numbers if you like, but her mother had testified that, here again, her term was that her daughter had become uncomfortable, okay? But she also went on to say that my daughter is resilient and she's okay. Well, that young lady, who I tell you, presumably graduated this year as a product of the Little Rock School District, and she's a credit to her district. I don't know if you've ever been in the PLSB hearing room. It's kind of cozy, but it's perfectly adequate for those purposes. And my seat just happened to be right beside the witness's seat, and so she was sitting right there when she and I were able to talk for a little bit. And I asked her specifically, and this is on page 72 of the transcript of the proceedings. I asked her, well, how you doing today? And she said, I'm doing good. I asked if you've been enjoying your senior year, and she said yes. And I asked her if she's glad that Mr. Utley is no longer at Southwest High School, and she said, that really doesn't matter to me. So I think you understand from the facts of the case that Mr. Utley got transferred to another campus, that is Metropolitan, as a result of this incident. And he finished the last school year as an employee of the Little Rock School District. So I just want to respectfully represent to you that I believe that the hearing panel got it right. They asked all the right questions. It's regrettable that any teacher did something that made a student feel uncomfortable. But I want to respectfully submit to you that there's not the evidence in this case that would rise to the level of a justification for revoking a teacher's license. Their recommendation was that his license be suspended for 6 months, after which he would be on a 2-year probation, and that he would have to complete and furnish written reflections on numerous additional training type videos and books and things like that. Mr. Utley acknowledged his poor lack of judgment in this particular situation, showed a high degree of contrition during the hearing, but wants to keep his teaching license. But I guess here again, I can't reiterate strongly enough that while certainly, regrettably, there are situations where teachers engage in conduct in which the only recourse is to revoke their teaching license and not giving them the privilege of continuing in that profession. This is not one of those cases. I just don't think that the proof, as far as, and of course, I think you all understand that detrimental impact to students is one of the sanctioning factors that the PLSB takes into consideration. It's set out, listed in the matrix, which is an appendix to their rules and regulations governing the enforcement of the Code of Ethics. And I just don't think that this particular case has proof of such a detrimental impact that it would rise to the level of justifying revoking Mr. Utley's teaching license. Thank you.
Thank you. Now Ms. James has 10 minutes.
As you know from reading the materials in your file, the educator in this case, Mr. Chase Utley, was an assistant principal when this happened. He was also a coach at Southwest High School in the Little Rock School District. And while in this role, he had multiple interactions, as you saw, with a female student who was a senior in high school that he had known since she was in the 9th grade. At the evidentiary hearing in this matter, the PLSB introduced into evidence over 600 text messages exchanged with a student during a period of around 2 weeks. The texts were about various subjects that were not all school-related. Mr. Utley didn't try to put a stop to the communication. It was inappropriate, it was overly friendly, and he encouraged the communication. And there's no acceptable reason or excuse for this. There was credible testimony at the evidentiary hearing to support a preponderance of the evidence. The mother of the student came to the hearing and testified as well. And she said that she thought Mr. Utley was grooming her child and that the text messages were inappropriate. She said, and this is a quote, "I think he was trying to be slick in his way of doing it. I think that's what grooming is. You don't overtly put it out there. It's actually done covertly so that you are not caught for what you are doing." She also testified that, and I think this is true, we don't really know the effect of what this had on the student yet. I believe this has all happened in the past calendar year, so we don't really know the effect of this. We've had students come and testify, and once they're in college and they have male professors, they have trouble because of similar situations. Mr. Utley also took photos of this student without her permission. He came to her workplace and took pictures of her and sent them to her. He referred to that as trolling. The student's mother, like Mr. Alligood stated, informed her that Mr. Utley was creeping her out. The student testified about him taking the pictures without her permission. She testified that she brought food to him. He asked her to bring food to him. She testified that he asked her for hugs at school. The communication became uncomfortable when he would text her saying he didn't get a hug that day, and that it was uncomfortable when she wasn't texting him back, and he continued to text her. She testified that he followed her around. She testified that Mr. Utley took photos of her friend on the school security camera and sent the photos to her friend. So there's all kinds of inappropriate interactions going on here. And again, this is an assistant principal. The evidence indicates that Mr. Utley has an interest in students that goes beyond what is appropriate for an administrator or educator at a school. You will see in the documents provided to you the report from a PLSB investigation in 2013. In that case, a student gave a statement to our office that she witnessed Mr. Utley kissing another student in the stairwell at East End. When the student witnessed the interaction, she evidenced surprise, and that was captured on the school's security system. The principal testified at the hearing that Mr. Utley knew where the cameras were and that she had actually gone back and watched this video footage. She saw the student exhibit surprise, called the superintendent over, and somehow in the time between when the superintendent was called and when he arrived, the video footage disappeared. We have screenshots and videos of Mr. Utley working on the school security system computers during that time frame. He denies that he deleted the footage. He denies that he knew how to work the system. However, the principal testified that that's not true. They often called on him for IT support because they were a new charter, and I don't think they had IT personnel at that time. The educator who was the principal at the school testified that my recollection, she believed that he deleted the video footage because she had just seen it, he was on the system, and then it disappeared. So either that was an incredible coincidence or he deleted the footage. And I believe he did not receive any sanction that came before you, I don't believe. However, I think that came down to a he said, she said. However, the principal, it's undisputed that that footage just somehow disappeared. Mr. Utley initially told our office in writing before it was recommended that his license be revoked that, quote, "I have at all times maintained professional and ethical behavior as it relates to my position." He then backtracked at the hearing and said he didn't agree with that statement. He also said in writing to us that his texts were mostly school-related. Then he backtracked at the hearing and said he didn't agree with that statement. At the hearing, he kind of minimized the text messages, oh, we're just playing around and whatnot. But what is clear is that as a principal, his conduct was inappropriate. As an educator, his conduct was inappropriate. And the PLSB argues that he was trying to set the stage for a relationship in the future by sending overly friendly, flirty text messages to a student, and that it would be quite a coincidence if the footage of a student witnessing him kissing a student in the stairwell disappeared right after he accessed the security system. The PLSB argues that Mr. Utley should not be in a classroom. At the hearing, we argued that the panel should uphold the recommendation of revocation, and I will stand by that argument today.
Thank you, Ms. James. Now it's open to questions, or do we have?
Open to questions.
Okay, now it's open to questions. Ms. Rollins, questions? Mr. Wood, questions?
Not right now.
Ms. Hunter? Questions?
I just want to make a clarifying, so this was originally on our consent agenda. Was the recommendation on the consent agenda revocation, or was it a written reprimand? And I guess I'm trying to figure out.
No, it was, the PLSB Ethics Subcommittee recommended that his license be revoked. As is his right, he rejected that recommendation, and we had an evidentiary hearing before the hearing panel.
Okay.
Several hours worth of testimony. The young lady, her mother, the principal from the former school, a lot of laudatory letters from administrative personnel on behalf of Mr. Utley. After having heard all of that and deliberated it, the PLSB hearing panel recommended that his license be suspended for 6 months, followed by which he will be on probation for 2 years, and coupled with a great deal of additional training and education on his part related to interactions with students and things like that. So it was presented to you on the consent agenda as the educator's agreement that his license would be suspended for 6 months, followed by a 2-year probation.
Based on the evidentiary hearing?
Based on the evidentiary hearing panel's recommendation, which he accepted.
Okay. And so then bringing it back today, we're back up to revocation? Is that, or is it?
Well, I mean, I wasn't here in June. It was my understanding that y'all wanted to pull it from the consent agenda just to take a little closer look at it and see if all of the sanctioning factors were adequately considered, which I respectfully submit to you that they were. And I like what you had to say in connection with Mr. Dumas's case, Mr. Wood, is that you're not prepared based on, 15 or 20 minutes today to overrule what the hearing panel spent hours addressing, and to which the educator agreed. I'm not trying to condone the tone or the volume of the text messages with this particular student. I just don't think that you've got the level of detrimental impact to a student that would be necessary to justify revocation of the teaching license. And let me point out, I mean, after this occurred at Southwest High School, he was transferred to another campus. The Little Rock School District wanted to keep him employed. He would be employed there today were it not for the fact that he had accepted a 6-month suspension, which necessitated getting him a job in the private business sector. He wants to return. The Little Rock School District considered him to be a valuable employee, and he worked at Metropolitan. He was transferred to Metropolitan and was very impactful there, as I understand.
May I ask some questions of you, Ms. James?
Yes, ma'am.
Or actually, I should check with Mr. Henderson first. Mr. Henderson? Do you have any questions at this point? Okay. Ms. James, so there was an incident that occurred in 2013. You referred to it East STEM.
Yes, ma'am.
And that became a letter of caution. Do you have any information? It's very surprising to me that you have pictures of him tampering with evidence, and that only led to a letter of caution.
Yes, and I can't really testify or explain why that was the decision. I would assume it's because it was, I believe that the student who he was allegedly kissing denied that it happened. I don't think that the student who witnessed it ever recanted that. And also, there wasn't any, I mean, you could see him at the desk, but you know, we're just, you know, it was either a coincidence or he deleted the footage. Maybe there wasn't enough there. I really don't know.
Okay, so then in 2017, it looks like the high school gave a written reprimand for fraternizing or socializing with students. Was that not turned into PLSB?
No, it never was.
Okay.
It never was. But he
How
stated
did that come out in this process?
Whenever we were looking at prior allegations, I believe that when our investigator was asking if there had been any prior incidents, that's when it came up.
And that was giving
Mhm.
a female student a ride home from prom. And so then
Yes.
in September 2023 is all the messages.
Yes.
During this investigation, was there any way to go back in time to see if there had been other messages to other students or other relationships?
I mean, we just have the 3. That's all that we found out about.
Okay, and then could you speak to, so the initial recommendation was revocation?
Yes.
And then during the evidentiary subcommittee, it turned into a suspension. What was sort of the mitigating factors that they lessened that initial sanction?
Let me look at the rationale just real quick. Let's see. It says that I believe this was meant to say the behavior, but it says the rationale does not meet the level for revocation, but does meet the burden for suspension and probation. It likely was impact on the student, but like I argued earlier, we don't really, we don't know what the impact on the student will be going forward. Again, if you look at the volume of the text messages and the content of the text messages, that's very concerning.
Are there levels to written reprimand? Like, is there a first level and then no, it's just, okay.
Yes, ma'am. Yes.
Okay, but at the least we have three different incidences spanning over 10 years of allegations at different schools and different locations.
Inappropriate interactions with students, yes, ma'am.
Any other questions, board members?
I do have some questions. I wanted to clarify just one thing. I appreciate Mr. Alligood pointing out my comments from the last hearing. I want to clarify kind of my approach to these. When it comes to findings of fact, that is a laborious process, and I believe that when other panels make a decision of these facts occurred, I lend a significant amount of weight to their pronunciation of those facts. When it comes to the judgment of what should be the consequences for those facts, I do believe that they are open to a higher level of scrutiny from my perspective, and I am more willing to insert my judgment in the consequences part than in the fact-finding part. So I just want to clarify that. That doesn't mean that I'm either direction on this. I am concerned about these text messages. What would be the highest level of consequences we could impose short of revocation today?
That would be suspension of license, which you can suspend it for however long you think is appropriate. Right now, it's 6 months.
Okay.
Followed by probation, but once he's on probation, he can go back to work in a public school.
Can you one more time, sorry, tell us what the recommendation was from the evidentiary hearing?
Yes, ma'am. The recommendation from the evidentiary hearing panel was suspension of license for 6 months, followed by probation of license for 2 years, $250 fine, coursework and readings. Would you like for me to list? Okay.
Was he asked to do any of that in the previous instances?
He only received a letter of caution. So no, ma'am. And then coursework, readings, written reflections, and then he would be responsible for the cost of any training or reading coursework.
May I say one thing? You know, much to-do has been made about him allegedly having kissed a high school student in a stairwell in 2013. Let me tell you, I've been representing teachers before the PLSB ever since it came into existence in 2008, and I'm here to tell you, if they thought that they had salty evidence that a high school administrator was making out with a student in a stairwell, they would not have given him a private letter of caution. I mean, there was no proof that he had tampered with any evidence. The young lady that he allegedly was kissing vehemently denied that that ever happened. And so, you know, he got a private letter of caution. But
that letter, but he received that letter of caution in 2013 and
did.
still chose to get in a car with a student in 2017 and still chose to visit a student at their place of work in 2023. Is that correct?
Yeah, in 2000, yeah, he violated the district's policy about giving students rides. There was a student who needed a ride home after the prom, and he gave her a ride home. There was nothing nefarious about it.
Fair, but having received a caution that you should not be in a room or in a situation alone with a student and still chose to do so.
I'm not sure when
You don't think that's showing poor judgment that he initially received a caution that he should not be alone with a student in a location?
From the 2017
From 2013.
2013?
Mhm.
I don't know that the private letter of caution expressed that in those terms. I'm not aware of that.
Okay.
And also, I would just point out, I mean, Ms. James contends, well, we don't know yet what the detrimental impact is going to be. All we know is what the young lady, who's intelligent and articulate and well-informed, told us at the PLSB hearing panel is that I'm fine. I was made to feel uncomfortable.
Right, but another student who received 611 messages, 55 emojis, and 9 pictures might not be fine. So we have to take that into account too, if we're gonna argue that.
Well, but we don't need to engage in conjecture, I respectfully submit.
Okay. Further questions, board members? Ms. James, can you go back to your original opening statement, the recommendation that was made by you?
Yes, ma'am. My argument at the evidentiary hearing was that revocation was the appropriate sanction, since the sheer volume of the text messages, the content of the text messages, and his history. I argue today that there's enough for revocation, but of course I'll defer to the board.
Thank you. Board members, questions? And Mr. Henderson, let me check in with you. Any questions from you? One thing that's circling around in my head is the discussion about a suspension might not have weight in another state. And we've seen individuals go to other states and make actions similar, because that's sanctioned and hold.
Yes.
So y'all if an individual applies for a teaching license in another state, unless it's revoked, you all don't share that information with that state, is that correct?
They would be able to see that they have a sanction here. How that would affect their teaching license in another state, I don't know.
Okay. Thank you. board members' questions, start to think about, it's the 3 motions again that have to be made for this case.
The first is whether the educator violated the code of ethics, and if so, what standards. And then the second is the recommendation for the sanction, and the third is the rationale.
So, and just to follow on that,
Yes, ma'am.
are we accepting or modifying the decisions of the hearing or the original subcommittee?
You can do either one.
Okay.
And we can change them?
Yes,
So we
and
could
you
say
can,
suspension for
you
5
can
years or
modify,
whatever.
it can be whatever you choose.
Questions, comments, board members?
So I'm going to make a motion that there was a violation of ethics, standards 1 and 2.
I'll second.
A motion by Ms. Hunter, a second by Ms. Woods. Comments or questions? Okay, all in favor say aye.
Aye.
Any
Aye.
opposed? Motion passes. So the second motion is in regard to the sanction.
Yes, ma'am. Accept or modify previous sanction.
Go ahead.
I'd like to advocate for a 1-year suspension with 2 years of probation. I think that keeping him out of the school for a full academic year would be a significant statement from us that his conduct was inappropriate and extremely concerning without passing the more onerous judgment that it rose to permanent termination of his right to be a teacher. He does have significant letters of recommendation in his favor. I respect, feelings, stronger feelings of more permanent as well. He should do a better job of keeping his nose clean from situations like this. And I feel like a year out of schools might make that clear.
Would you still keep the probation?
I would, yes.
I agree with, does that time period, he's out of school now.
He is not working in a public school right now, and I just wanted to clarify that the year suspension would start from today. It
No,
wouldn't-
I would maybe ending June 30th, because didn't he leave employment in May or something like that?
He finished his contract with the Little Rock School District and is now in private. So I appreciate what you're saying, either having the year, I'm sorry. Nobody's ever said they couldn't hear me. Even having the year commence in June would accomplish your stated purpose.
That's right.
Even
That way-
6 months
that
from
way
now would
he could
actually.
go back to the schools next academic year.
That was my point. This should be considered part of that time.
Right.
Thank you.
Okay, there's a motion on the floor.
So I'll make my
Is there a
motion to
motion?
do I'll make a motion to I guess, is it to reject the recommendation of the PLSB?
Modify.
To modify the recommendation to a suspension ending June 30th, 2025, and 2 years probation thereafter.
May I ask a
There's motion, is there a second?
May I ask just a quick
Yes.
clarifying question? Typically, we don't move someone from suspension to probation until they've completed everything that they are supposed to complete on the suspension. That's what makes it a little bit tricky if we give a specific date. Would you like to add that suspend until June the 30th of 2025 as long as he is meeting all requirements of the sanction in order to be switched over to probation?
I think so.
Okay, I'm sorry.
Yeah.
Like all of
Yeah.
his court costs and everything have to be paid by then.
Yes.
And
I respectfully submit that your rules already require that a person satisfy the other elements of the sanction before their license would be reinstated, but your point's well taken.
I just want to make sure it's clear that if there's a specific date, that doesn't mean we're just
Okay.
moving over.
Yeah, that's fine. So I'll modify my motion to be modification of the PLSB recommendation to a suspension until June 30th, 2025, with a 2-year probation if he has completed the other requirements of the suspension. Is that a way to say it? Or
Yes.
the other requirements of him?
Of the requirements during the period of suspension?
Yes, for reinstatement.
And would you like all of the same trainings,
Yes.
everything that was recommended by the hearing panel?
Yes.
Trainings, coursework, written reflections?
Yes.
Okay, thank you.
Okay, so there was a motion by Mr. Wood, and is there a second?
I'll second.
A second by Mr. Bragg. Comments or questions?
So, I'm gonna just make some comments here. I'm going to vote against this. I just have I'm struggling very much with this situation. I think he's showing patterns, and I think that his behavior, is somewhat predatory. Finding young women who, are vulnerable, they are in a vulnerable state whenever they are in high school. We do not know the long-term impact of any kind of interactions like this. I think that it is completely inappropriate, and being told once should be more than enough. And I also believe that as educators, the line should not and cannot be remotely fuzzy. It has to be very bright between what your role is and what the student's role is. And if that student attempts to make it fuzzy, it is your role as the educator to shine that bright light between you and that student. So I respect your position, but I will be voting against this.
I respect yours as well.
Comments or questions on the motion? And we'll take a vote. Should we do a roll call? Okay. Since I know I would assume we'll do a roll call. Mr. Wood?
Yes, aye.
Ms. Hunter?
No.
Ms. Rollins?
No.
Mr. Henderson? Mr. Henderson, do you want to make a motion? Mr. Henderson, do you want to make a motion?
Yeah, I'd like to make a motion.
I mean, not make a motion. Do you want to vote? Yes or no? Sorry.
Yeah, I like to, obviously, before I second, I just like to say that to add to Mr. Wood's comments, I think these are some very serious allegations, and also I think this is a very slippery slope. So, you know, whatever standard that we're making, we got to make sure that, you know, it's on point and it's on line. So I definitely
Okay.
like to second that.
Do you vote in agreement with Mr. Wood's motion for a 1-year suspension or to end?
Yes.
Okay, yes. Mr. Bragg?
Yes.
Ms. Woods?
No.
And I will go on record with a no as well. Yeah, so motion failed. So table is open for another motion, and this is on the sanction. So we'll
I'll
need-
make a motion that we modify the PLSB board's decision and agree in revocation of this license.
Okay, there's a motion to modify the sanction to become a revocation by Ms. Rollins. Is there a second?
Can I just have a question for the board. If it were 5 years, would that change if it was suspension? I voted no because I feel like 1 year is still too light, in my opinion. But like if we put forth a 5-year, I feel like I could say yes to that, because that's a statement. and it also requires him to get the necessary training and pay all of the court costs. And so I struggle. I feel like 1 year is still too light, but I don't know that I wouldn't agree to a 5 year. So are you just, revocation is where you're at?
He can come back after how long, if there's a revocation?
If it is a revocation, he can come back after 10 years unless it's sexual or physical abuse. I don't believe there was anything overtly sexual in this one.
So even if we suspend it for 5 years, that's 5 years earlier that he could get his license.
If he completes all of the conditions. Mhm.
I think what, I will speak out of chair role, it's the other states that get me.
It's the what?
Other states, that
Oh,
if you move, as far as suspension versus revocation. I also don't know if we have, the ability to provide training that might rehabilitate someone from inappropriate actions with students. I think our discussion yesterday, certainly talking about the nature of text messages and emails, and it certainly, we've had shifts over the past 10 years, but we do know there is that line. So that's where I'm thinking of.
If I could just have, Ms. James, if you could clarify reciprocity, that if another state were to ask, is this educator's certification in good standing, what would that response be?
If they're, I would say they're not in good standing if they're on suspension. If they're revoked, I think there's a greater likelihood that they won't be able to get a license somewhere else. We've had a case before that came before you all, and they wanted to revoke him for something similar, but because we had not revoked him here, they couldn't. But that's just one state. I have no reason to believe Mr. Utley's gonna go try to work in that state, but that's just one example.
Okay, so back to, we have a motion on the floor.
Is that with a $500 fine, Ms. Rollins?
Yes.
Okay.
Is there a second to that motion?
Second.
Okay, a second by Ms. Hunter. So, just to clarify, this is a motion to revoke the license with a $500 fine?
Mm-hmm.
Okay. Got it. Any questions or comments before we take a vote? Okay.
I'll speak against the motion, not because I don't respect your positions. I don't believe that his conduct rises to the level of permanent termination. And while I fully appreciate the sentiments that have been expressed, I caution against punishment of imagined future conduct. And so I think people should be punished for what they have done, not for what they might do in the future. And so I'll vote against revocation, because I don't think that these facts rise to the level of permanent revocation.
Okay, I'm gonna ask a question, take a point of privilege to ask a question.
Yes,
If the
ma'am.
educator wanted to be here, could we have pushed it to another month for them? And that's a department question.
We could, but I mean, his attorney is here, and I don't know if he would.
Because we've had cases where people have brought in 10, 15, 20 character witnesses.
We wouldn't be able to hear witness testimony if we had the hearing at a different time. Well, according to our rules, it would just be the PLSB, the educator, and his attorney, and then our investigator.
Okay.
We
Oh,
don't.
no, I mean our board. Like it
Oh.
could be on a agenda. It could have been in the next month. Could they have requested to do it next month to have the educator here?
To have the educator speak.
Yes.
But he wouldn't be able to call witnesses.
Okay. So we haven't. I guess people just bring people and they give us
They
letters
just-
or something. Yeah.
You might be thinking of licensure or
Okay.
another type of case, but I would argue his attorney is here and probably saying the very same things the educator.
Yeah. There's just something about looking someone in the eye, too. Okay, so with that, we have a motion and a second.
Can
Any
I
more
ask a
questions?
question, maybe
Yes.
backing up about the text messages? Were they sexual in nature, or?
They weren't overtly sexual in nature. He was taking pictures of the student and sending them to her, making comments about how she's booed up with her boyfriend or a gentleman. Just lots of lots of text messages, almost more like friends, kind of, he really walked that line. And remember, she was a senior in high school.
I would characterize them as really not very sexual at all, but way too friendly, just inappropriately friendly. And it just, it's uncomfortable to read it, not because the content, if he were to say it to her in passing in the hallway, you would not have much concern about, where'd you get that Starbucks? Who cares? But there is something about this many text messages, this friendly, you know, text messages feel hidden and secretive, and it just, that is really what brings us to the level of he needs to know he is crossing a line. But I don't read any of it. If I felt like it touched sexuality or grooming, I would be all in favor of revocation. But he does. I don't even really think he tiptoes to that. The pictures of her were of her sitting in his office, and you know, she sent a picture of him down on the court at a basketball game and that kind of stuff. There was no.
Yeah, she stated at the hearing that he brushed up against her, and the mom didn't know that this was happening. The mom shut it down once she found out. The mom felt like it was grooming, for what it's worth.
And I respect that, and I don't mean that it. I can't say that it was or wasn't. I have no idea. I just a unbiased, uninvolved reviewer of the facts. It just.
Well, it just seems like this criteria for revocation is more of a sexual nature of the communication, so.
You can mitigate it up or down.
Yeah, I mean, I think, and you know, that, like, pictures of her with, you know, the little heart emojis around her face. I mean, those things were troubling to me, and those were the ones that were encroaching on the getting out of that bright line area. I just, and the repeat, I think, is what, you know, again, everyone makes mistakes, and but to not learn from them, I think, is the biggest mistake.
Okay, so we have a motion on the floor. There has been a second. We are in questions and comments now. Any further questions or comments before we take a vote? We will do roll call. Okay, and so the motion is a revocation with a $500 fine. We'll begin a vote. Ms. Hunter?
Yes.
Mr. Wood?
No.
Ms. Rollins?
Yes.
Mr. Henderson? Mr. Henderson, I know your camera's off. I don't know if you're in the ability to take a vote right now or not. Okay, I'll come back to him. Mr. Bragg?
No.
Ms. Woods?
No.
Mr. Henderson? Vote for revocation. Your vote, yes or no, for the motion on the table is for revocation?
Second on that.
Okay, so that's a yes or vote. Is that right? Can you repeat that? Did you say yes to the vote motion for revocation?
You're breaking in and out, but it sounds like you said the motion for revocation.
Yes.
Yes, I'd like to make that, please.
Yes, and I will vote yes as well. Okay, motion passes. So next we have, the last motion is on the rationale.
Yes, and I can read the rationale to you if you would like, from the hearing panel or from the ethics subcommittee. Would you like for me to read the ethics subcommittee since they did vote for revocation?
Yes.
I'm happy to read both, but I can read that one first.
I think what they voted to modify was the hearing panel's recommendation. So they ought to hear the hearing panel's
You can,
rationale.
read both.
I offered to read both.
Yeah, we'll read both.
Okay. I will start with the hearing panel's rationale. Let's see. Educator admitted to having inappropriate text conversations with a student. Educator also breached confidentiality laws by sharing student information with other students. Educator violated multiple district, state, and federal policies or law to include, and these are district policies, licensed personnel video surveillance and other monitoring, licensed personnel social networking and ethics, licensed personnel code of conduct, and FERPA. Educator did maintain inappropriate communications and relations with a student, which did not escalate to that of a sexual nature. Educator did violate district, state, and federal policies. He has a prior history with the Code of Ethics as a letter of caution and did receive a letter of reprimand from a school district for similar ethics violations. And then the last sentence says the rationale does not meet the level for revocation, but does meet the burden for suspension and probation.
And then
The ethics subcommittee rationale?
yes.
Okay. That was. The educator sent over 600 non-school related messages to a student. Some of these text messages were sent at late/evening hours. The student said she began to feel uncomfortable when the educator came to her place of employment and took photographs. There is a lengthy history of inappropriate interactions with students spanning back to 2013. The educator has previously been before the PLSB board and was issued a letter of caution for inappropriate interactions with students. The educator would give the student his debit card and allow her to leave campus to go get food. The educator took no accountability for his actions. The educator should have known his actions were a violation of the Code of Ethics for Educators, high negative impact on students. You can remove or add to any of that.
Okay, so those are the two rationales.
Yes,
So we
ma'am.
need a motion to accept or modify
Yes, ma'am.
a rationale.
I would move to accept the latter that you just read.
Okay.
Which I don't remember which one that was.
That was the ethics subcommittee for the revocation.
But I think though he did ultimately take some responsibility. Is that?
Okay.
Is that?
We can remove that. The
Did he
accountability
later
piece.
take it?
At the hearing? Yes, ma'am.
Okay, well then I think it needs to be removed if he did.
Okay,
So
I'll
that would be our-
remove.
I'll motion to modify the evidentiary hearing rationale.
No, I think it's
A subcommittee.
Subcommittee,
Sorry.
right,
Yeah.
rationale.
The
To
subcommittee
accept
was
it
the latter one.
With
the-
one
yes.
modification, yes, ma'am.
Okay, so there's a motion to modify the subcommittee rationale, but accept the rest of it. Is there a second to that?
second.
There's a second. Okay. We will take a vote. Ms. Hunter?
Yes.
Mr. Wood? Did you
No.
hear it? Okay. Ms. Rollins?
Yes.
Mr. Bragg?
Yes.
Ms. Woods?
Yes.
Mr. Henderson? I don't know if you can hear us. Okay, I don't believe he's on right now, so we will not take his vote, and I'll vote yes. Motion passes.
Okay, thank you.
Let's take a break before our next case. I'll allow you to speak, but come up to the microphone.
I'm sorry. The gentleman who is participating remotely, didn't he vote in favor of Mr. Wood's motion for a one-year suspension? Can, you know, at the end of a jury trial, you get to poll the jury. Can we just make sure that that gentleman understood that what he was doing was voting to revoke Mr. Utley's teaching license?
I think the chair clarified 3 times on what that exact motion was. So it was a separate motion and a separate vote.
Madam Chair, I mean, are you satisfied that he was well aware of
Yes.
the vote he was making?
Yes.
Okay, well, thank you.
Thank you. So let's take a break. We'll come back at 11:35. Thank you. We are back together. We are requesting a change to the agenda at this point, and we'll need a motion to go ahead and hear action item number 7. Sorry, I remembered my agenda printed off is different. Okay, number 7. Is it this individual? Okay, to hear action item number 7, and then to hear from Ms. Whitlow in the Blytheville School District, and then we'll take a break for lunch after that. So if you're not one of those two, then know that we will not get to you until after lunch. So we are looking at item number 7. We need a motion. Okay, a motion to change the agenda to hear number 7.
So moved.
Second.
A motion by Ms. Hunter, a second. All in favor say aye.
Aye.
Motion passes. So we will go to number 7.
So we'll proceed. Carly Saraceni, Assistant Commissioner, Educator Effectiveness and Licensure. Today before you, we have a licensure action, which is different from PLSB. What you just heard was the standards on ethics. This is a licensure action that initiates from a background check. Those background checks are FBI, state police, and child maltreatment. And this particular action is child maltreatment, okay? So before we start, we're gonna let Ms. James explain how much the procedures for this hearing, okay?
Whitney James with the department.
So it's number 8 on the old.
Ms. Saraceni is passing out just an updated timeline. I don't believe any of the content is anything different than what you've reviewed. We just rearranged some of the dates to make it flow better. This is what we sent to you.
Thank you.
And at this time, I will go over the procedures for a licensure action. They are different from PLSB. Each party will have the opportunity to present an opening statement of no longer than 5 minutes, beginning with the representative of the division. Each party will be provided 15 minutes to present their cases, beginning with the representative of the division. Every witness giving oral testimony must be sworn under oath by the chair of the state board and subject to direct examination, cross-examination, and questioning by the state board. And then once all of the discussion and questions are finished, then each party will be given 5 minutes to present a closing argument, ending with the division. So the educator will go first for the closing argument. The division has the burden of proving by preponderance of the evidence that cause for the proposed licensure action exists and that the recommended disposition from the division be adopted. Any questions about the procedures?
So Mr. Marks will swear you in. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you. Ms. Saraceni, 5 minutes.
Okay, before you, you have an updated exhibit list and timeline. And so we are going to start with the timeline because we want to make sure that you understand and have all the facts and it flows exactly the way it happened. Mr. Marks had a true finding case that was presented to the DHS Office of Appeals and Hearings, and it was upheld and his name was put on the registry. He initiated a background check in May of 24, which was earlier this year, and upon going through the whole entire background check, we received information and verified that Mr. Marks has a true finding for sexual abuse on the Child Maltreatment Central Registry. from an incident that happened back in May of 2019. No PLSB allegations were filed on that particular incident that happened in 2019. And you're asking, there's some discrepancy dates because that incident occurred back in 2019, but he was not put on the registry till 23. And then when he initiated that background check in 24, then it was brought to our attention that he could not, he had a hit, he was on the registry, and his name was a true finding on the registry, therefore cannot be employed in a school district in Arkansas. So therefore, it gets us to where we are today, that he has asked for a hearing in front of you to state his case. Again, I think some real important facts are that he had his hearing, that he appealed to DHS, and it was upheld in 23. Any other questions for me? Then I will let Mr. Marks.
I do want to ask a clarifying question. Just
Okay.
in there, because this case is different because it's a licensure action.
Yes.
What does a motion look like at some point at the end? Is it
Okay.
to waive the licensure?
Well, you can do several things. You can permanently revoke after a hearing. You can suspend a license. You can place or grant a license on probation. You can impose a monetary penalty up to $500. It's very similar but different.
But we don't have to have the three motions.
No,
is that
you do
correct?
not
So
have
just
to have
one
the
motion
three.
with
Yes.
the sanction. Okay.
And require, again, you can impose restrictions, but, or take no action.
Okay, thank you.
All right. Mr. Marks?
No, Mr. Marks.
Good morning. First, giving honor to God, I'd like to thank you all for your time and allowing me to speak before you. I was real nervous getting up here today, but you know, I got a little boy on the way and probably got to go back to the hospital because my woman experienced high blood pressure, so it really ain't no more nerves. I just want to get through this with you guys. All right, so I do have representation. However, I did not know that he should be present today until Tuesday when Miss Whitney James called me. I called and told that it would be best for my attorney to be present, but it was too late notice at that point, and he already had other cases planned to be present for. My attorney's name is Luis Lloyd, out of Malvern, Arkansas. But he did tell me that he would be available via phone if we need to call for questions or information, though. It was by my advice of a previous attorney that I was told not to say anything at my last hearing about this. Not even to deny the accusation. That is why I'm still having to fight this false claim. So I'm okay with the opportunity to speak before you as a human being without my representation. I have been waiting for this opportunity really a long time since I found out about my placement on the child maltreatment list. So I am grateful to be here today, answer any questions you all have, and just to be truthful and honest. Thing is, after my first hearing, where I was advised not to say anything, I did not even know the outcome of my appeal. I was in the process of getting ready to find another job. I was ready to start my head coach career. I had to call DHS myself to find out I was still on the list due to not denying the claim. If it were not for this Port Council, I would still be on salary and able to support my growing family while waiting for my hearing in November, because November is my other hearing. I would like to speak a bit on my character and the accusation at hand. When this claim was made in 2018, I was a new young teacher in a predominantly white school, Fountain Lake, as well as being the first black teacher and coach. So I don't know if they was accepted to the change. After teaching and coaching at multiple schools since, I've been at 3-4 school districts since Fountain Lake, this was definitely the most uncomfortable and unsupported I felt by an administration. Due to this, even after being investigated and having no wrongdoing found on my part, I feel as though any claim or complaint, even unsupported, would have been used as an excuse to end my position at this school. On to my character as a teacher. With how my students engage with me in the classrooms and in the halls, with the boundaries I set in how my classroom is conducted, and with my decision to treat these young adults as human beings with a level of mutual respect and understanding, I strongly hope that one student taking advantage of that and spreading a self-proclaimed rumor will not take that from me. In my years of teaching since this accusation took place, my classroom management skills have consistently been praised and valued by various administrations. It comes to mind last year when I was at Whitehall, Miss Debbie Jones, the assistant superintendent, came in and sat while I taught a class and wrote one of the most sweetest notes ever about my classroom management and about the rapport I build with students. I feel as though the student who made this claim was dealing with their own personal struggles, saw the pool and likability I have with other students, and possibly wanted a little bit of that popularity or to feel a level of engagement with others. I have heard from other students that the students who made the claim in 2018 has since admitted it was false, and I am aware that she was dealing with her own personal life struggles as a teenager and has been in trouble with the law. I hold no ill will against this person, and I truly hope she finds a positive path for her life. I just hope this false accusation does not ruin the path and success I have worked for. Last and not least, I really enjoy my career and am fulfilled by it due to the difference I am able to make. I would not be trying this adamantly to fight this accusation and my existence on the child maltreatment list if I truly have done anything that warranted it. I have a family at home and a son on the way who will be here any week now. I can support them with another job or career field. I have no problem going out and finding that. But I wouldn't be doing what I feel like God placed me here to do, which is making a difference in students and athletes' lives. Again, I am very grateful to be here today and finally speak on this. If my previous attorney had advised me differently, I truly feel that this matter would have already been solved. But I really am appreciative of this opportunity to speak about this personally. Due to this, I have been out of work for months, and it is truly embarrassing to be in this position for something I honestly did not do. I have kept every employer informed about this situation since my placement on this list. I am very fortunate to have a position waiting for me at Maumelle High School if this matter is resolved or waived. This has just been a major stressor and financial burden in my life, and I am ready to accept the board's decision so I can move forward with what is next for me. If the board decides in my favor, while I will not be back on salary yet, according to Coach Mock, I would be able to be back coaching immediately starting tonight and making a difference in young adults' lives. Thank you, guys.
Thank you.
At this time, either one of us can take questions.
Board members, questions? Ms. Rollins?
Why was this not sent on to the PLSB board? The school didn't file?
Is all we know, because the incident happened in 2019 at a particular school, and since then, according to records, I know that was part of your packet, I think he's been at 5 different districts at this time, and no one filed a PLSB. We went back and looked at our records to confirm nothing had been filed. But again, he was not put on the registry until 23. So there is a lapse in time that we do not know why that a PLSB was not filed an ethics complaint. Because this is child maltreatment, and it's not, my investigators or that are in my division does not go out and investigate when it's a licensure action. That's not our, we do not have to provide that because it is a licensure action, because it has not been brought forth to a particular allegation against an educator. And there's no way back to go back and find out why unless we call that particular district.
Mr. Wood, questions?
So you didn't do this?
No, sir.
And your attorney advised you not to deny the allegations?
Yes, sir. The attorney that, I let him go. I want to say, I don't know the right term for, but I fired him after it. He advised me not to say anything at the time of my hearing, just to sit there. And as you can see in the file, it says that basically that my silence was used against me. And I also want to state that at the time of that hearing, the other party, the student, didn't show up, and then the investigator that investigated it at the time of it wasn't there either. It was somebody else on the case. So like, yeah.
He give you any explanation for why you should not deny the allegations?
He did not give me any explanations anyway, and then like I said, this guy here, man, whenever I called him, whenever I had to call DHS and found out that I was still on the list and I tried to get a hold of him, I had to take off work, drive to his office. He wouldn't see me. He wouldn't talk to me. So it was just very stressful, and I would probably still be working at Whitehall now and waiting for the hearing in November if it wouldn't have been for his counsel. Because if he would have told me after my hearing in December, hey, we lost this hearing, okay, then I wouldn't have applied for a new job and got popped on my background check. Whenever this happened at Found Lake, they pulled me out of class, they took my phone, they embarrassed me. There was no text messages found, no evidence, no case, nothing.
And you say now that the student, the accuser, has since recanted?
I have a good relationship. I haven't talked to that person directly because, of course, that doesn't make sense. But I have kept great relationships with a lot of the kids I coached back then. Jake Turner, for instance, was a great baseball player. He's in college now. I've talked to those students over the years and have heard from many of students, and they probably would have came and witnessed today if I would have known that I should have brought, witnesses, because I heard that earlier. I would have brought them, and they would have witnessed that. And like I said, you can Google this person's name, her name. Like I said, she I think in 2023 she was a burglar. She got arrested for burglary. In 2021 she was maybe a Jew. I mean, and I'm not here to paint a light on her, to help myself. But I'm just saying, I'm just saying she ain't got the cleanest record.
So how old was she at the time? I guess this is in 2019. What grade?
Let's see. So I was teaching 10th through 12th grade. I was teaching about A&P and biology. So she had to been in 10th grade.
Okay.
I'm thinking, ma'am.
Okay. Thank you.
More questions?
Well, one other question. Yeah. So, Ms. Saraceni, no, it's for you. She mentioned that you've had numerous jobs,
Yes,
over the last 5 years or so. Can you explain the movement from one district to another?
Oh, yes, ma'am. All right, so whenever I left Fountain Lake after this incident, I took a whole year off. I took a year off teaching just to let this settle down. I went to Northwest Arkansas to teach. Okay, when I was in Northwest Arkansas, after a year, Coach Eldridge, J.R. Eldridge, he, big-time coach at Arkansas, but he had got hired on at North Little Rock. He called me, hey, I need you. Will you come work for me? All right, so that's how I got back in at North Little Rock, okay? And then I was at North Little Rock for a year, teaching science and coaching football. And then Coach Eldridge got a job at Farmington. So, and I got my kids is down this way, so I couldn't move to Farmington. So that's when I went to Glen Rose School District with Coach Keener, and I worked 2 years there. Okay. After that, Ron Mallett was. Everybody know Ron Mallett. That's probably my best friend. We hung out every day. He was head coach at Whitehall, so that's why I went to Whitehall. And then I was leaving Whitehall just because it was just too much, as you can imagine.
Sure. Thank you.
Questions, Mr. Bragg? Ms. Woods, questions, Mr. Bragg?
I don't necessarily have a question. I do find the investigative report interesting because they basically say the issue's inferred by his silence, which I don't know that that's appropriate. So that's not to you necessarily, just as I sit here and read through the report. They took your lack of defending yourself as evidence of guilt, and I don't agree with that.
And that's why I told Ms. James, she was like, are you comfortable without coming here without representation? I'm like, yeah, because I done put my life in other people's hands with this case, and it's been a dark cloud over my head because they haven't led me in the right direction. So that's why I was glad to speak for myself.
More questions, Mr. Bragg?
Question from Ms. James. Was there evidence that pictures were sent?
If you look in the report, because we didn't investigate this, all we have is the DHS report. When they interviewed the student victim, she said that there were pictures, and I believe the witness that they also interviewed stated that she had seen the pictures.
Okay.
We don't have any evidence in the packet that the student or the witness recanted what they said during the investigation.
May I say something? And, sir, I'm just saying, and honestly, I can say that I seen a picture of Miss Hunter. You know what I'm saying? I could say I seen a picture of Miss Hunter. Who's to say I'm lying? You know what I'm saying? Anybody can say, can go in an interview and say that they did this or got this and that. But if there's no evidence or nothing like that, what's your basis?
May I ask some questions, Ms. James, or Ms. Saraceni? So and this is where I still don't always understand. So this was filed with DHS.
Yes, ma'am.
It went to the Arkansas State Police Crimes Against Children Division.
Yes, ma'am.
Was it processed in a court system?
I do not know if there were any criminal charges that.
No criminal charges, and we don't know why the district didn't report any PLSB at that point in time.
Yes, and I sure don't know why they did not.
And we still, and Mr. Marks, I guess to you, if you don't mind coming back up to the microphone, do you have any reasoning from them as to why, it took 4 years to get on the list and what that process was like?
Honestly, Ms. Moore, the true finding claim just ended up in 2022. It just ended up in the mail at my doorstep. And after that day, I just took the right means to try to get it fixed.
I think back to you, Mr. Marks. Do you feel like you will not find yourself in any situation like this again?
Oh, for sure not. For sure not. I wish I could have brought some of the students that I done taught in the past, or just any. And like I said, in the file, you can see some letters of character witnesses and that type of stuff. I really make a special connection with kids in the right way. And I say this has been hard on me because I done been at 3-4 other school districts and then built so many relationships, and I had to go to another school district, Maumelle, and meet all these amazing people just to get it turned down due to somebody that I paid a lot of money to that was supposed to protect me. I guess you can see what I'm saying. So, but just to answer your question, no, I'll never be in a situation like this ever again, ever.
Okay, thank you. Board members, additional questions? And Mr. Henderson, at this point, are you on? Do you have any questions?
I'm confused as to what happens in November.
All right, so like I said, I think I'm saying this wrong, right? But do you want to speak on that? Thank you. I appreciate it.
That's okay. That's okay. As like it was at DHS with us yesterday, and they talked about 1 year. You have 1 year. You have to wait 1 year before you can petition for your name to be off the central registry. So when he had his in November of 23 and they upheld it, it will be a complete year, and I think you already have a court date this December. November.
Yes, ma'am.
So it's a complete year.
Okay.
Does that clarify that question? So it's been a year this November.
It does.
So you're continuing to appeal, I'll just say appeal.
Oh, yes, ma'am.
But then the last time, I just want to make sure I got this right, but then the last time you appealed, it was still a true finding because you were silent.
It was true finding because I was silent.
Okay.
Yes, ma'am. Mm-hmm.
I'm not sure you could characterize it that way, though. That's going a little far. It wasn't a true finding because he was silent.
Fair.
It was true finding while he was silent.
Gotcha.
They reviewed other evidence
Right.
to come to their
Yes.
conclusion.
Thank you.
And that's important.
I was referring to the investigative report, not to the ALJ hearing, or the maltreatment hearing.
I understand. Okay, I think
Does that make sense?
I don't know. But Essentially, I mean, I have respect for your right to plead the fifth. And DHS is the government, and when you are in front of the government, they cannot compel you to testify, and you have a right to plead the fifth, and your pleading of the fifth should not be held against you. I don't know exactly if you were pleading the fifth. It kind of sounds as though that might have been what the attorney was advising you. I don't know. I would love to know more about that. It does cause anxiety in people who are trying to decide the facts. But that group of folks reviewed, and it kind of goes to what I said earlier, they were in a position to review the facts, and they came to this conclusion.
Yep.
But then I'm also frustrated by the lack of prosecution, because the accusations are awful.
Yep.
And I don't.
Just like if I would have did those things that's on their report, we know that I've been in jail right now, incarcerated. Cause with the technology and things these days, man, you can find pictures sent to people, and inappropriate pictures, text messages, all that can be recovered, and they recovered nothing. Not even my cell phone number in her phone.
Ms. Saraceni, if the appeal is denied and he's then still on the registry.
Yes. So today, again, if an educator is on the Child Maltreatment Central Registry or has a disqualifying offense on a criminal conviction, which this is the Central Registry, the state board is authorized to revoke a license permanently, suspend a license, place a person on probationary status for a period of time, or grant a waiver if requested, which Mr. Marks is asking for a waiver for you to waive. So when you waive something, it's waived indefinitely. And so I think that's where you have to understand that if you waive or grant his waiver request to waive this, even if in November he goes back to DHS and they uphold it again, you've waived it and it's waived forever on this incident.
I think I'm still unclear. So the alleged event happens in 2018, but he doesn't get put on until 2023?
Yes, ma'am. That's why that's why we redid the timeline, because I wanted you to see that it was not put on the registry until 23. I think he had his hearing in the first.
So you've only been through
interview.
one round.
One round.
Basically, we put you on and you said, no, I contest this.
Yes, ma'am.
And so they went to a hearing.
Okay.
And then
there's not like a hearing that finds it. You appealed it once, and now you're on a second appeal.
Correct.
Okay. Just making sure I clarified that.
Appreciate that.
Mm-hmm. Mm-hmm.
This was the original time, and so this is his first attempt at an
Yes.
appeal. Okay.
His first appeal was in November 23. And as DHS stated yesterday, they have to wait one complete calendar year before they can ask for the second appeal.
And I know that you can't answer this, but I mean, what was the delay? I mean, what we heard yesterday sounded like things kind of moved.
Well, that was my question. Is there not
quickly.
a statute of limitations to something like that? I mean,
Again, this is DHS.
Right.
It's not through our department.
No.
And I know that Ms. James can speak as well, because I'm not an attorney. I'm just the assistant commissioner bringing this to you. Again, this always puts us in a precarious situation sometimes, because it is their processes, and we can only bring you the information that we currently have. And again, the incident happened. We have the incident 2019, and it's in the timeline what day that it happened. Again, when a school district does not at the same time file an allegation with us, it's hard for, we have no jurisdiction, we don't have anything that we can do other than go on with the evidence we had. And when he finally initiated a new background check, this hit came up that he was on the central registry, a true finding. And then that puts us into our background check rules.
Sure.
And that's not the rules for ethics.
I'll just make a comment. I feel like the allegations are serious. But I feel like if this was his character, there would be more. He's been to 5 schools. And this was not a pattern of behavior and he didn't know it until he went to do a background check, which I don't know that you would want to do a background check if you were messing around with kids, but.
Can I say something?
Sure.
Honestly, Ms. Woods, I was celebrating after my hearing in November. Like January came around, I didn't hear from my attorney. I'm celebrating. I'm like, okay, we on to what's next in life. So I'm ready for what's next, Ms. Woods.
Okay, board members, questions, comments? Mr. Henderson, do you have any questions or comments?
Not at the moment.
Okay, thank you.
Dr. Moore, would you like Ms. James to come up and instruct the board what's the procedures next?
Yes, thank you.
Okay. Ms.
And
James.
we'll start with the floor.
So Mr. Marks, as you know, is on the Child Maltreatment Registry, which is, we are bringing this to you to make a decision. He has requested a waiver. So essentially, if he gets a waiver, it's like he's not, for purposes of being in a school, it's like he's not on the registry. Okay. So today, after the hearing, there are a couple of things you can do. You can decide to grant the waiver, which would mean for purposes of his background check or the Child Maltreatment Registry, he's able to work in a school. You can also revoke his teaching license. You can suspend it for a terminable period of time. You can place his license on probation for a terminable period of time with the license to be revoked or suspended. If the probationary period is not successfully completed, you can impose a monetary penalty, require him to complete appropriate professional development programs, education courses, or both, require him to complete licensing examination, credentialing examination, or any other examination. I don't think that applies to him. Impose other conditions or restrictions, or any other penalty that you feel is appropriate. You can take no action against the license. However, he is, I believe, asking you to decide today on the waiver so that he knows what is next. And then we are also asking that you make a decision on his license.
Any questions or comments?
So was the true finding based on solely the testimony of this one student, but then the evidence that is explained in here was not substantiated?
Can you ask me that one more time?
He's denying that there were any pictures or anything, and so there was never any substantial evidence of that was ever presented, even in the true finding.
Well, there was also some behavior that the student alleged happened, and she had a witness that allegedly saw the messages. As far as what was actually recovered from the phone, if anything was, I'm not sure. Just based on the facts that, I mean, we just have the DHS report, and then all of it was upheld at the administrative hearing.
More questions or comments, board members? Okay, floor is open for a motion. thoughts to consider? Anyone want to share before a motion?
So we're waiting on an appeal on his, he has an appeal pending.
Does DHS have an obligation to report to the local prosecutor's office if they think there's child abuse?
I don't know right offhand,
Okay.
but I guess evidently in this case,
No.
I don't know.
It was reported to the prosecuting attorney.
Oh, where did you see that?
A report to page 4 of the.
The document?
Yep. There is a report to prosecuting attorney with, it's a few pages long. I guess I'll just speak to my thoughts on this, and, you know, Mr. Marks, I'm not gonna sit here in judgment of you or pretend that I know what happened. You're asking us to waive the state law that does not allow you to have a teaching license when you're on the child maltreatment registry, and I believe that when someone comes in here and asks us to waive that they have the burden of establishing enough doubt that we would believe that a waiver was appropriate. I don't think that, for me, you've met that today by just coming in here and denying it. And I'll rely back to what I said earlier, that a panel that is charged with determining the facts of cases like this has determined that the allegations are true. And I don't see how I could, based on, 20 minutes, well, just a second, based on 20 minutes this morning, and with only your denials, nothing to corroborate, nothing to support your denials, could I say that this panel was incorrect in their decision? And so I would vote to deny the waiver request.
Okay, is that a motion?
It is not at the moment. I guess
Okay.
give a second for people to express opposite views should they choose to.
I feel like I have an opposite view only because I'm not, I think there was a lot of errors. I mean, I think if you do an investigation in 2018 and you don't put somebody on the registration for 5 years, I have an issue with that. I'm not gonna sit here and nitpick another attorney's decision whether you should have or should not have. That's not my place to do something like that. But we have documents here from multiple individuals that the lady recanted. Whether she did or didn't is his word against hers, but at least at this moment we have the same side. He's saying he didn't do it, and she's saying he didn't do it. And I feel like in this, unless I misunderstood, they didn't have text messages or anything when DHS did their investigation. So they took her word and his lack of word and made a determination. And I just don't know that I agree with that. I mean,
Where is her recanting her story?
I'm inferring that from all of the character witness stuff that was sent to us at the back of the package.
Okay. Anything specific?
No, I'm just the character witness.
Just the whole
All of them that
gamut of what
repeat
it
to,
says?
it's my understanding, I believe she's recanted this.
If we deny the waiver based on the fact that he's on the list now, and this decision is reversed, he can come back.
That is correct.
Is there a time limit? I mean, like, if let's say it's reversed in November, can he come to our December meeting?
So if you deny the waiver today, then I believe he could have another background check. And then he would not receive a hit for being on the child maltreatment registry if his name is removed.
So then there would be no waiver, nothing to waive.
Correct. And he would just, in the meantime, he would not be eligible to work in a school district.
No, I think what you were asking was if he goes in November and gets off, can he come back to us in December and ask for his license back? Is that what you were asking?
But he wouldn't have to. Yes, but
Right,
then
oh,
I
okay.
realize he doesn't have to because he could.
Because we're not revoking, we're just not renewing.
Unless you choose to revoke today.
I'm not putting
Okay.
that forth. I'm just being very clear. I'm just making sure I understand.
Right, he would not have to ask for a waiver if he is not on the child maltreatment registry. So he could move forward with, are you up for renewal?
No, it's just.
Okay, it was just about, okay, he's still, that's what I thought. He still has a license that's good for, the next little bit. He's not up for renewal. This was just a background check because he was starting at a different, district. So this was for employment, not renewal.
So is this like a probationary period then? What
No.
he's in right now? No?
Well, he had a background check. Oh, do you mean with employment?
Yes.
I am not sure. His background check was older than what the district could accept for him to begin employment there, and that's where this came up. I don't know if he's in a probationary period with his employer. I'm not sure.
Like, are you teaching in a school right now?
I'm not teaching. I just got a great relationship. Okay, yes, ma'am. I'm not teaching right now, but I just got a great relationship with Coach Maupin at Maumelle and athletic director and Dr. Freeman, and they just let me know that if the waiver goes successful,
You have a job. But right now, you're not
No, ma'am.
in a public school.
no, ma'am.
So to be clear, if he's cleared, then his license is effective anyway. Okay.
Sir, if I'm cleared, I'm back teaching science tomorrow.
Yeah.
So basically, we're trying to accelerate. I mean, like, with the assumption, it's a big one, that November is favorable to you, then what you're asking us to do is to accelerate what will happen anyway. Is that right? I mean, like.
Yes, but there's also the potential that he doesn't get off in
Correct.
November, and then
No,
we
no,
just.
No, I understand.
If you deny his waiver, then he cannot teach. If you revoke his license, that's a separate issue, okay? If you deny his waiver and in November is successful for him, he can do another background check and he will not have to stand before you asking for another waiver because it's no longer necessary because his background check is cleared.
What's the typical turnaround time on an appeal from DHS? Like, I mean, he could be heard in November, but is it gonna be April before they render a decision?
I mean, that, again, that is not us.
Because it took him 5 years to put him on it, so that's my only hesitation.
But surely they would,
Could
if
I-
it's an appeal and it's appeal process, they should rule that day.
5 years to put me on it, in 3 years I can go into the appeal process.
James, you're the attorney.
It's been 5 years since, I guess, the finding or whatever, and it's been 3 years that I've been on appeal trying to get in with DHS to figure this out. Mr. Woods, can I ask you something?
No.
No?
I just wanted to add that I believe at this juncture, when he's asking to have his name removed from the registry, I don't think they're gonna rehear the whole case. That's my understanding. Hopefully it would be a quicker decision. I don't know.
So then what do they do on an appeal if they're not rehearing it?
I believe it's a petition for review on procedural and maybe credibility. I don't think they're gonna rehear all of the facts, probably look at the procedural issues. Again, I'm not 100% sure on how long it would take for them to make a decision.
Could I add something to this discussion about the effect of granting or not granting the waiver? According to what we have in the agenda, the paragraph there, it says, per Arkansas Code annotated 617-410, the board shall revoke any existing license not up for renewal of any person who has a true report in the Child Maltreatment Central Registry. I don't read that to give us any wiggle room. If we deny the waiver request, we shall revoke the license.
Is that y'all's reading as well, Ms. James?
The statute is a little bit confusing because it says up top, you know, you shall revoke, and then down further, it says after a hearing, you can suspend, you can place the person on probation, and gives all of those other options.
Okay.
And
I feel
that's from the law.
Yeah, I was gonna say, I feel like we've not applied that, if that is the case. In a lot of situations, we've deviated.
Okay.
I mean, whether right or wrong, because this is kind of a gray
Okay.
statute.
I do have a question again. Going back to when this initially happened in 2019, we have no information from the school district as to why it wasn't turned into PLSB?
No, ma'am.
But they are, I mean, a principal and a superintendent should, if incidents like this happens, they should report it, right?
Yes, ma'am.
And I think with LEARNS, now that we have that 24-hour rule, that there's a substantial, it would have probably been reported to us. But we did not have that back in 2019.
So you all also had no knowledge of this until, at which point now that the
We did
background
not
check
have
happened?
any knowledge until the background check was initiated this summer and when we received notification from DHS.
Okay.
That was one of the first things we did, is go back and look and see if we ever received anything. I went to my chief investigator and said, have you ever heard of this? No, it was never reported to us.
I have questions.
Well, I mean, I may be like completely off target here, but you know, I mean, for me, I really want the outcome of DHS. I mean, that's the information that I need to, so do you. Nobody more than you. I understand that. But I mean, and to your point, Mr. Wood, I mean, if we have someone on the registry and we shall revoke, I mean, that's pretty clear in a lot of ways. So, I mean, I'm wondering if we can somehow, you know, waive this, but then deal with his license in a different way with suspension or probation until such time as the DHS runs its course. I mean, that allows everyone to kind of like, everything to run its course. Because I feel like we're out of order here a little bit, and from a timing standpoint, a little upside down. Am I confused? I may be.
No, ma'am. No, ma'am. So you can place the license on suspension, you can revoke, and also you can take no action on the license. If you wanted to deny the waiver, that would, I believe, accomplish that's what I was talking about later on in the statute. It gives you some options. You don't have to take action on a license. If you deny the waiver, then that might accomplish what you're seeking to do as well, without having to
It'll
suspend
keep him out
or.
of the classroom because he is on the child maltreatment registry, so no school can put him in a classroom.
Should not.
Right.
And so the waiver would be denied. He can reapply for a waiver
If he's successful.
if he is successful after his November hearing
Yes.
appeal.
Yes.
But will he require a waiver once he is, you know, if he's successful in November? Because he then would no longer be on the registry.
That is,
I mean, so
Yeah.
I think what I'm saying
Yeah, I
is
think
that we approve the waiver, but then we deal with it from a licensure standpoint, and he is on probation until time. I mean, you know, like with stipulations of until it's resolved with DHS. I mean, I don't know if that's
I think that's
allowed
kind
or
of
does it
saying
make
two
sense?
different
Oh, yeah, they're very
things.
different.
so I guess my thought on that would be, why would we do that? If he fails in November in that appeal, does this board feel comfortable allowing him back into the classroom? If it is the desire of this board to, if he fails in November, but we want to help him return to the classroom, then granting the waiver may be the way to go. But I feel like denying the waiver, my vote would be to deny the waiver today and let whatever happens in November be the fate of his future ability to return to the classroom. Because if they remove him from the child maltreatment registry, he'll be able to return to the classroom. And if they don't, I do not feel comfortable with the facts I do not feel comfortable with the facts presented, paving his way back to the classroom.
I didn't hear all of the session yesterday. Did anyone ask what the success rate of getting off the child maltreatment registry yesterday? No?
No,
Nobody
ma'am,
asked, okay.
that didn't come up.
Because if they're only reviewing technicalities, then nobody would ever get off. Do you know what I mean?
Mm-hmm.
Right.
They may be looking at more than that. I wish I had more information for you,
No.
but.
This is not on you. These are always a problem.
So can we table this until we get some questions like that answered? Until we can understand further, like what will happen at his appeal?
You could.
I'm just like trying to have a conversation.
Oh, I get
here.
it.
Yeah.
I'm trying to put forward
Well, I guess here's the question: if could he? I mean, how many times could he come to our board to seek the waiver?
I mean, if we table it, then we would be able to bring it back to you once there's a decision. I don't know. I mean, I believe he's seeking an answer today, but again, the board can, do what it would like.
I think my fear is they have not shown evidence of being timely. And so if we were like, we would get an answer in November, I'd be like, let's just wait till November and let them hear it. The problem is his original hearing was in 2018 and he didn't get on there till 2023. So I have no faith that this is going to be resolved anytime soon.
Right. And I understand that. I mean, today, he's on the registry as it stands. And so regardless of how long it took and whether or not it was timely, I mean, he's on the registry. So it kind of leads us back to the same place. Yeah. If you decided not to take action on the license, he could come back at a later time or after the hearing. If you deny the waiver, it's going to have the same effect as him not being able to be in a classroom now. It's just a question of whether or not you want to table the decision on the waiver or everything.
I don't really see where it makes much difference.
No.
I mean, it's all depending on the November.
He still is not
Mhm.
eligible to work in a,
Yeah.
and he won't, again, he won't need a waiver if he's successful after his hearing. But with the hearing decision pending, even if it does take a few months, then he's still on the registry throughout.
I mean, effectively, he could lose a year. I mean, just
But
to
if
be
he,
realistic.
yes,
I mean,
if he had a
he's out
waiver,
this year.
he'd be able to teach during that year.
Mr. Henderson, I want to touch base to see if you had any questions or comments. Okay.
And just to be clear, there is no waiver for a time period, right? It's either an all or nothing sort of deal. It's not like we have a waiver for 12 months or the calendar year.
If you deny, then you deny.
Sure.
Okay, and then in December, or November, if he's cleared, you're not revoking a license or you're not suspending a license. If you just deny his waiver today, then if he's cleared in November, as soon as he initiates another background check, it will be cleared. Okay? Or you could possibly have no action and ask him to come back at a later date after his November hearing with DHS. And if it's successful, then he will not have to come back. If it's not successful, you could ask him to give you certain information, and I think he would do so.
Probation then would allow him to go to work tomorrow if he has a position.
If you make a decision other than denying the waiver, if you put him on probation, then once that probation time is up, it's up. And so this particular violation would not come back up again.
But if we put him on probation in November, comes back and they don't accept his appeal, then probation is out and the appeal would override.
It's my understanding that's not quite how it works. If you make a decision today for suspension or probation,
You would still have, if you wanted him to be able to return to the classroom, you'd still have to grant him the waiver. But that waiver, there's not a time limit on it. So if he's given that waiver, we can't come back and say, well,
Okay, yeah.
it's almost all or none.
We had,
To me, the cleanest thing is deny the waiver, wait till November, and if it's cleared, then there's nothing else we need to do.
That is correct.
Mhm.
Then it would not have to come back to you if he's cleared in November.
Right. And if it's not cleared, he could always come back
At
before
that
us.
such a time, yes.
Mr. Marks, I'm going to move to deny the waiver. It is by no means judgment on you, and I wish you all the luck in November, and I hope that you're successful in your hearing with DHS, and you can return to the classroom as soon as possible. But if that hearing were to go not the way you want it to go, I would not feel comfortable overlooking what has been presented and having you in the classroom. But that's it. So with that, I'll move to deny the waiver request.
There's a motion to deny the waiver request. Is there a second?
I'll second.
There's a second. I do a question of clarification. So then if he could come back again after that point to us, if it was still on. Okay. Any questions or clarifications, board members? Okay. We will take a vote. Ms. Hunter?
yes.
Mr. Wood?
Yes.
Ms. Rollins?
Yes.
Mr. Bragg?
Yes.
Ms. Woods?
No.
Mr. Henderson? Mr. Henderson, this is a vote to deny the waiver. No? Okay. Okay, motion passes. Motion passes to deny the waiver. And they'll be in touch with you about next steps.
Do we have to vote to take no action on the license?
No.
We don't, we can just not do anything?
I think that carve out allows us to.
Carly, if you answer Mr. Woods' question.
Because you denied the waiver and you're not taking any action on the license.
Okay.
So that is, at this time, because no action was taken on the license, the one motion was denying the waiver.
Okay.
Okay, are we good? Do we want to move on to roll call? Okay. Yes, Mr. Marks, you can make your comment.
All right. Like I said, once again, I would like to thank you all for having me here today. Like I said, I didn't have high expectations just because I understand the nature of it, but I don't, like I said, I would just like to say I don't necessarily agree just because if someone can have 600 text messages to somebody and you give them a chance, and I got a case where there ain't no messages found at all, and then somebody going into an interview saying he did this and that with their friend. That's kind of hard, Mr. Wood, but I thank y'all for having me today. That's not fair, but thank y'all. But like I said, we're looking at factual evidence, 600 text messages that he done sent to a female student, and you was willing to give him a chance, but you shut my chance down.
Well, we'll be back in touch as you proceed in the rulings. I'm sorry. And we did revoke that license with the 600 text messages.
Yes.
Okay, so we're going to take a break in licensure cases. We're going to hear from the Blytheville School District, Ms. Whitlow. We appreciate, I know a lot of you have come far today and appreciate your patience. It is a longer meeting today. We will take a break after this, so if you're not from Blytheville, understand that we'll be after our lunch break that we get back to you all.
Okay, good afternoon. Sheila Willow, Associate Deputy Commissioner and Director of the Office of Coordinated Support and Service. And as you said, we have several representatives from the Blytheville School District here today, as well as board members, and they're prepared to give you a report. But before they come, I'd just like to share with you that we have had members of our team and several external partners on site since the last community meeting, and the district has been very responsive. They've been willing to do the work that's been asked of them, and what we can tell you is that the work has been very direct and intensive during the time that we've been working with them. They did get school started, and we have someone on site working with the principals, getting in the classrooms, very frequently getting in the classrooms to support the teachers. They've also had the co-op director working with the board and the interim superintendent. I have also met with some community members during that time and attended the local board meeting. So we're very present in Blytheville right now. I do want to share with you also that I've been working with the board president trying to find a superintendent or someone that would be willing to come and serve in that role. And that has been a challenge. A challenge because of the perception that the board is dysfunctional, and there's concern that if they move into that role, they would not be able to serve as a superintendent and be able to do the things that need to be done. So that's our challenge now, is to find someone that is qualified and that is also willing to come and serve. I believe that you saw the survey and you heard that from the people that responded, that is the perception in the community. So there's very much a concern about the functioning of the board, their roles and responsibilities, and understanding those. So we do have the board chair here today. He's going to speak to you about their responses to their response to the survey, as well as their plans, both short-term and long-term plans. So I do want to share just a couple of pieces of data with you, if that's okay as well, before I go. We checked on enrollment, and they are down 87 students since the end of last school year. And we had someone from Lysanger, a team from Lysanger went yesterday. There are 42 teachers now that are working, unlicensed teachers that are working under a waiver. Of those yesterday, Melissa Jacks has shared with me that there are 12 now that are completing their paperwork that will be eligible for license. And those that they met individually with each teacher that is not licensed and helped them work on a plan working toward licensure. So if it's permissible for the board, I would like to ask the interim superintendent to come and provide her part of the presentation.
Okay. Thank you.
Good morning, all. I am Jennifer Blankenship, serving as the interim superintendent for the Blytheville School District. As we start with our staffing, Ms. Whitlow introduced or stated that we have 42 who were on waivers, unlicensed teachers, and that we were able at our primary school and our core areas to get 5 of those. They've been working with Ms. Melissa Jacks. A great team came down and met with those teachers, and so we are able to work on getting them on the right path in licensure areas. 6 at our primary school, 2 at our elementary school, including 1 in special education, and 2 at the high school. The team was able to also meet with everyone to map out a plan for those teachers to get them into some type of program where they were able to get some in the RPEP because they had a late enrollment. Virtual instruction, last year at our primary school and our elementary schools, we had quite a few virtual teachers. We do not have any. This year, we have some at the high school, our AP classes through Virtual Arkansas to make sure we have that rigor that they needed. We're offering pre-cal, and we will have to do chemistry. That's been an area where we've not been able to get anyone. Also, as far as staffing, we're working on our recruitment and retention plan. Signing bonus, we plan to adjust the salary schedule because those teachers who are there, they've been there, they come back, they have a license. There needs to be some difference between those licensed teachers and those who are on the waiver. Also incentives for our high needs area. We do recognize that some areas such as chemistry and the math areas are hard to find. So we need to, and we will address that and come up with some incentives for those areas. Teacher support. We've had Dr. Miller and others who've been on campus with our principals, going through observations, showing them how to do feedback. They've shown us aspects of things in the system. We had Mr. Andy Sullivan come down. So they're in the classrooms. They're getting observations with the feedback. We have our classroom leaders who are working with our teachers, not just our novice teachers, but all teachers in different areas. We get some major support from the co-op who come in. They give us mentors. Literacy instruction support, TNTP piece, which is very vital, K-3, focusing on literacy, and the SOAR grant. Those things are vital to our literacy instruction for our lower grades, and we're just making sure that everybody feels supported in different areas. We're getting extra support in science and math also through our co-op. Principal support. Once again, Mr. Sullivan, Dr. Miller came down. We had some test training, LEAS training on the system, getting in that system, knowing how to make it work, having teachers do their own self-assessment. Also, Ms. Whitlow and that team has been there from OCSS, offering support and just giving us ideas and suggestions and just taking us through the process of how to make things work as we move the district forward. Letters training, which is also literacy support. Our student support service director, multi-tier system, we're going through all that. The National Time Tracker, which will enable our principals to track their time to make sure they're spending more than 50% of their time on instruction. The goal is to get to 60% of your time each day on instructional practices. And then with our master schedule, we started a new program, Cardonics, which will help us track the numbers and make sure our classes are going to be balanced. Our business office, we do now have a finance director. She was hired a couple of months ago. We have accounts payable and we have a payroll specialist. So we have a fully staffed business office. They're new people. So we had a small agreement with the Arkansas Public School Resource Center. We are going to expand that contract to get more support services so that we'll make sure that we're going to be fiscally sound going out. There's a team that's going to be on site tomorrow from DESE to go over fiscal services. They're going to meet with the finance director, payroll specialist, and our federal programs director. One of the key things you guys talked about when you were in Blytheville, the community survey. So the survey did go out. Some of the key concerns, teacher quality. We talked about and addressed the number of teachers who were unlicensed to get them on the pathway, to get them licensed, to get them taking their praxis and get them in programs and get them the support they need to become licensed teachers. Bullying came up, many of the survey responses, especially in our lower grades. So address bullying complaints immediately. When a parent calls about the complaint or a student goes to the office, those are going to be addressed by the principal and the counselor. They'll meet with the students, whoever has the complaint, make that parent contact to let them know that this is serious, we take it seriously, and we're gonna get to the bottom of things. Restorative practices where you try to get the groups together and you talk through what the issue is, and most times it's somebody said, and then you come together, you work through that. But it just needs to be addressed and immediately and notify all parents involved. Academics, the rigor and challenges. So we've addressed that, with offering more AP classes, getting that rigor through Virtual Arkansas. Our partnership with ANC. We do have students who take concurrent classes. We have the technical center down there where we send students. And increased student engagement. We have lots of new curriculum that will allow for students to be more involved, more student-centered, not just the teacher up talking, but getting those students involved, more engaged. A lot of parents were concerned about the technology use. So the new curriculum does involve more students, groups, more things like that. And we also, at every building, we have an intervention time. So everybody gets that intervention time where they can focus on academics. At this time, we will hear from Mr. Hammond because this is the portion about the Blytheville School Board. I don't know if I should ask for questions or just wait to the end.
Let's do questions now if on this portion of it.
questions? Okay, then we'll keep going and get done. Thank you.
Okay, thank you. Good afternoon, everyone. Thank you for having us here for this update. My name is Desmond Hammond. I'm currently the board president of the Blytheville School District. I would like to also acknowledge our board members that are present with us. Just to give you a quick update, to develop this presentation and to work with the district administrators and leaders, the Blytheville School Board had a work session to identify some needs that we would like to share and update with you on. And these are the needs that we will discuss here. The Blytheville School Board, we took ownership of what was in the community survey, the perception of the Blytheville School Board. I'm here today to tell you that the Blytheville School Board is functioning and we're working in unity. Although we may not agree on all things, but we are putting the kids first in every decision and every conversation that comes before the Blytheville School Board. Now, once again, we take accountability for what was in that survey. We take ownership for what was in that survey, but we are better than what we were, and as we prepare to go forward in the future, we will be a functional board that's geared and centered around student achievement and growth and helping our community to be the best. So through the community survey, we've identified some needs for training within our board. Roles and responsibilities, understanding where we are on the bus, the correct seat as the board, and identifying those responsibilities and us understanding what we're looking at when information is coming to us and the roles that we play in helping getting the outcomes that are desirable for our district. District finance, we put in policies and practices to understand our district finance team. APSRC will take a bigger role. We're looking for more resources and support there within our finances to help our district to remain financially solvent. Academic and instruction, we have to have a presence there and understand our role in the decisions that we make to make sure that we have the right information present to our district leaders and getting the results down to the school level to our kids. We're also working with Arkansas School Board Association to identify intensive, direct, intentional support for our board at this time. I'll go into some of our short-term goals. As Ms. Whitlow mentioned, that we're in the process of identifying a superintendent or interim superintendent. I just don't want this to be in anybody, and I speak for the board when I say I. The board doesn't just want anybody to fill a seat. You're breathing. We need someone that has high intensity around human capital, identifying the needs that we need in our district, getting the right people on the ship for us. We need also support around instruction and curriculum. This person should have a solid foundation with curriculum and instruction. That's our biggest needs. And also district finance, someone that knows the policies and procedures around different things that are within our school district with district finances. We'll also conduct a needs assessment. We're going to ensure that our building leadership teachers ensure support for our building leadership. We're looking for external partners to come in to help our building leaders, even our district admin and leadership team. We've been working with Pam Castor with the Crawleys Ridge Co-op. We've identified some of those vendors that have been approved through the Rivet system that we're going through now, and our district team is actively working and have made contact, and we have board presentations and coming this month in September to present different services that can help our district. Continuing with our external partnerships, Ms. Whitlow and her team has been very valuable to the Blytheville School District, giving us fresh perspectives, giving us perspectives that we need to focus more on, and giving us the right people to help support our leaders. The Crawley Ridge Co-op, Ms. Pam Castor and I and the district leadership team had an opportunity to meet. We went over the RFP process. We discussed different external partners, different services, vendors that could help us in some of the needs and areas that they've identified. APSRC, they're coming on to be, I guess, the big brother, big sister of our finance department. We're going to have checks and balances where some things are not going unnoticed or unknown to the board, so we will avoid any pitfalls around our finances in the future. Just the added support that's there. Long-term goals. The create requests for our RFPs if we were to enter into transformative agreements, we want that opportunity and option on the table. We want to be ahead. We want to be proactive. So that's why we have it listed as one of our long-term goals. We want the help and support, and we know we have areas of support that we need help in, and we've identified those through the external partnerships. Immediately, we're hoping to address some of those needs where we may not have to enter into a transformative agreement in the future if we see the data supports the progress that we need to make in Blytheville. Like I said, the rivet, the vendors, and the transformation contract. And I will close just by the portion of the Blytheville School Board, remembering our why. Our students are our why. Everything that we do, we want it to be focused on our students. A lot has been taken away from that focus from different reasons, but we will not take any discounts or cut any deals to get away from student focus. We will be primarily focused on the student success of the Blytheville School District. That's our why. There's nothing more, nothing less. Our students are our why, and they deserve the best of us. Thank you.
Thank
Questions?
you.
So I'll start by making a comment. And first, I want to thank the chair and interim superintendent for being here today and providing an update to the board. When we went to Blytheville, it was probably about 2 months ago.
August 1st.
August 1st. You remember that day? I was a little unfiltered and honest. We were very concerned about what was happening in that school district. And we were very clear about what needed to be done and what were the immediate next steps that we wanted to see and provide an update to this board. And so I'm going to say I'm cautiously optimistic about the future of Blytheville because I want to make sure this board understands they delivered on everything we asked them to do. And so to me, I feel like there's adults not taking ownership for the lack of systems and structures that should have been in place all along. Have we arrived? No. And I think we all agree moving forward that we want to continue this relationship. But I meet with Ms. Whitlow often on the progress of our schools under our state authority and our care and our list of schools that we know we want to see improvement, and she reports back favorably on the relationships and the conversations. As we move forward, I think you're right, getting the right individual to lead that school district is imperative. There's still concerns about declining enrollment. Like that trend needs to stop. And adding those accelerated opportunities, showing the community that you can operate together as one united voice on what's best for students is a big step in regaining that confidence and trust, because your community doesn't have confidence in the district. So we've got to, hopefully that trend stops today and we can start rebuilding and regaining that trust. There is no reason with the opportunities available to the students in that community, in that region, for them to not have every door opened for them to be successful beyond their wildest imagination. So I want to make sure the board understands that we've made some progress. I don't think this is the last meeting or conversation that this board needs to have with Blytheville. We are definitely going to be monitoring student performance. I'm appreciative to hear the chair talk about we may need some external partnerships. We may need some external help. And the fact that they have really reached out to the School Public Resource Center to get a handle on finances is big, because we were very concerned about academics. We were really concerned about the direction of their finances, because if they're losing students, in essence, they're losing revenue, and expenses weren't being reimagined with the level of revenue, and it was very much upside down. So I'm appreciative of your conversation today, and welcome any feedback from the board on next directions or steps. I know for us, we'd like to continue this dialogue, continue this conversation. We'll have progress monitoring data from our first assessment probably in the next month in our core subject areas. So academically, we can really get a handle on where these students are performing and make sure we have the partnership with our literacy coaches and academic supports, that the teachers have the right resources and training that they need. When we were there and we talked about unlicensed teachers, I think one of our biggest areas of concerns was especially in those primary grades, those foundational years, K1 and 2. If I remember correctly, between those 3 grade levels, they only had 1 licensed teacher in our foundational literacy years. So to hear that we've added some more, 6 more, that's
6 at primary and 2 more at the elementary.
That's
so that's 8.
That's a big change in just a few months. And so that's the kind of reaction we were hoping to get. And we want to reverse this trend and keep building this up and moving forward. So this is, that's why I say I'm cautiously optimistic, but I want to keep having this positive dialogue.
Board members, questions or comments?
I don't know if I have any questions. I'm just, I was there in Blytheville. And to see the community come together, I was so hopeful. And you could just feel the energy in the room and the passion that they had for your children. And you are pulling it together, and I'm really, really proud of you. I'm, again, very hopeful, and your board chair, my hat goes off to you. You've really done a lot of work just this last, 6 weeks? Yeah, that's great. And to see that you recognize that the board needs training, that's huge. And just continue to work on that. I'm a past school board member, and I understand, boy, you can really lift up your district, but you sure can pull it down if you're not working together. So thank you so much for understanding that and really, really working on it. So.
Thank you. Did you want to make a comment?
No, I was just going to say thank you. And that community piece, we've been getting calls, so the community is really, stepping up and asking what can they do. We had that big think tank with Mr. Freddie from ADE, so it's really helped a lot. So they're really wanting to help in the district, and we're going to continue to meet and show progress.
I really hope you get some more of your students back. Hopefully they'll.
Oh, that's the plan. Yes,
hopefully
ma'am.
they'll come back, because you have
Thank you.
you have a great community, and you could really feel it in the room that day. So
Thank you.
Yeah.
And if I may, just on that topic, me and Ms. Whitlow, I think I don't work anymore. We're in constant communication because we want to get this right.
We need to talk about that.
Yeah, right. I don't work anymore. But just to say, we welcome the support and the resources. And the thing about it is we're being transparent as we can be. We don't want to hide anything. The skeletons that are in the closet, let's pull them out. Let's talk about them. And when you say the community that's there, me and Ms. Whitlow challenges our district team. You're your biggest supporters. Put the information out. You're marketing your school district to parents, to community members, and everybody around you. What are we doing different to make a difference that people want their kids to be in Blytheville School District? When we have those conversations with the district administration team, they've been very receptive. And we are on a path forward now that I think when we come back in a couple of months or whenever we're invited back to see that progress, we'll have more positive outcomes and reports that are data-driven, that you can put a finger on and say, hey, I've seen them move the needle from one certified teacher to 6, then 2 in the elementary school. We're gonna make those improvements, and we're gonna get the right people in the right seat on the right bus to move Blytheville forward. Thank you.
More questions or comments, board members to my left? To my left. Mr. Henderson? Mr. Henderson, did you want to make any comments or have any questions?
I don't really have a question, maybe a comment. I think unquestionably the state board and the department leadership understands my position on the school district. You know, when I think about that, I think about the same standards of all school districts in Arkansas, the standardization of the level that we hold them all to. And I am happy to see that, you know, we are looking forward, we are moving forward. And we also now, we're talking about roadmap, we're talking about plans, we're talking about goals. So personally, I'm very happy for those efforts, and I can see that we definitely have some really good things in the works.
Thank you all. Ms. Litlow, anything else from your team to share? Okay. Thank you. Thank you all for coming in today, and it's a drive, so we appreciate you coming in early and meeting with us today. Did we have any public comment on this? Is there anyone that wanted to speak on this? Okay. Okay. Then with that, we will take a break for lunch, and let's go ahead and be back here by 1:45, and we'll continue item number 5 on our action agenda. Thank you again, Blytheville. Okay, we're on.
Thank you all. I know some of you have waited all morning, and we appreciate your patience. We are going to continue on for action, our action agenda. We're on item number 5, a PLSB case. Ms. James, we're spending a lot of time with you today.
We've just
Thank
walked
you
around.
and your team for the work that y'all do. It's very difficult to do it. Whitney James with the department. This case is regarding Hannah Fulmer. This is another one that was on our consent agenda that was pulled to the next available action agenda. She is not present today, but we do have proof that she received her hearing notice. We sent it to her by secured server, and we have proof that she did open it. I can go ahead and proceed with the PLSB's argument unless we need this is our 3rd hearing, so you know that it's typically the educator would go first and then the PLSB, just 10 minutes each.
Yes.
But she is not present.
Okay, may I ask a point of clarification?
Yes, ma'am.
Could she have requested to put this on the agenda for another month if she couldn't be here today?
Yes, ma'am. Yes,
Okay.
ma'am. We have heard nothing from her. We have notification that she has opened the link. She's not working in a public school. That may be why. I can't say.
Okay.
Yes, ma'am.
Okay, thank you. We'll continue.
Okay. Let's be very short. Ms. Hannah Fulmer received a written reprimand from the state board on May the 11th of 2023. She violated standards 1 and 2 of the Code of Ethics, and it involves students. It was not the same type of thing that caught your attention when it was on the consent agenda most recently. In that case, the educator and a colleague filmed a TikTok video with students while on campus. The video was not sexual in nature. However, the video had inappropriate music playing, a Nicki Minaj song, if you're familiar with Nicki Minaj, while the educator and a coworker walked into a classroom wearing sunglasses. In the present case, the educator posted a Snapchat video of one of her 17-year-old students and basketball players in which the student appeared to be intoxicated, and in addition to making other statements, asked for another fireball shot. The educator was the person who created the video and was laughing in the background. She did admit in her interview with our office that the student consumed alcohol while at her home. She said she didn't know how much the student consumed, that she had been drinking as well. She stated she didn't intentionally post the video to Snapchat. I think she hit the wrong button on Snapchat, but she did create the video. The student spent the night at her home and slept in her bed. And I'm happy to answer any questions that you have about that case that would help you make a final decision.
Okay. Board members, questions? Ms. Rollins?
Excuse me.
Bless you.
I don't have any questions.
Mr. Wood?
I don't remember what the discussion was around why we pulled this from the consent agenda. Would you remind me?
I pulled it because I was concerned that there had been a previous incident, previous PLSB sanctioning, and then this was the second one, and a suspension of 1 year felt like a light sanction in my personal opinion, and that's why I had pulled it.
Gotcha.
Okay,
I don't have-
questions,
I
more
don't have any
questions?
more questions.
Okay, Ms. Hunter?
None from me.
Questions? Okay, and I don't believe we have Mr. Henderson. Are you back with us this afternoon? Okay, I'll go ahead and ask my questions. I want to
Yes,
hear the rationale for the PLSB as to why they felt the 1 year suspension was an appropriate response.
Sure. The rationale for the suspension was video evidence shows that the student was at the educator's home and under the influence of alcohol. The educator acknowledged that she gave the student alcoholic beverages, Fireball and vodka. The educator acknowledged that the student spent the night at her home after consuming the alcohol and they slept in the same bed. The educator has a prior PLSB case for which she was issued a written reprimand. The prior PLSB case was pertaining to the educator's interactions with students, high negative impact on students. The educator should have known her actions violated the code of ethics. That was their rationale.
Was there conversation about revocation?
I don't remember from that particular meeting if they talked about it. They probably were going up, they didn't believe that a probation was appropriate. Typically, anything with alcohol would be suspension, but I understand your concerns.
I think it's the alcohol and the staying of the night.
Yes, ma'am.
Is that not considered, I mean, a child maltreatment or?
I believe this was reported to DHS, but it was screened out. The students' parents did not want to pursue any criminal charges.
Okay. But that doesn't, I mean, I'm looking at the sanctioning rubric
Yes,
that we
ma'am.
got yesterday.
Yes,
And
ma'am.
it's just hard to believe that a suspension was their determination.
Yes, and that sanctioning matrix wasn't in effect at the time that they made this decision.
Okay.
They likely were looking at the one or more violations and everything that formally was under the suspension column. That's what they were using then. However, you all are free to modify the sanction however you see fit.
I am resonating in my head are comments that Ms. Hunter made this morning about that line that teachers should not cross, and this feels like a very egregious line that was crossed, and that's why I pulled it. But I will step aside and see if anyone has any further questioning or comments at this point.
Just for confirming for myself, the educator did not dispute any of the information you just shared with us.
That is correct. She did say that there was no sexual relationship or inappropriate relationship as far as sexual goes, but she did not dispute that the student consumed alcohol at her house. She didn't dispute that she posted the video. She didn't dispute that the student stayed the night and in her bed.
Did she have students in her own house the same age? Do we know?
I don't think there were any other students there at the time. I think it was just her and this one student. My investigator is nodding her head.
Oh, wow. Okay, so this wasn't a whole thing. This was one student at one teacher's house spending the night, and we're not saying that, how do we, I mean, we're taking word for word that nothing inappropriate happened further than alcohol use.
That's what she said, yes, ma'am.
Okay. Further
I do
questions or
not have a
comments?
problem setting a precedent that if a student spends the night in a teacher's bed, we will revoke their license.
I'll go with that.
I'm not sure that shouldn't be added to the matrix.
Yeah, that just really stands out. And, you know, if there had been more mitigating, I need to hear more mitigating factors as to why they came to that suspension.
Well, she was invited here today to present mitigating evidence, I suspect.
Okay, I want to check, Mr. Henderson, if you're able to hear us, if you have any questions.
Complete assumption on my part, I was thinking it was a party. Like, that's what I had just drawn.
Yeah.
Right.
Got
and
drunk,
had-
said, hey, just, I mean, I was just,
And had other, you know,
Yeah,
teenagers
yep.
at the house. I mean, that would be wildly inappropriate. Any
Also
alcohol
Still
use.
inappropriate.
worthy of revocation.
yes.
Yeah. Yeah. Okay, so questions or comments, our floor is open for a motion, and this is, remind us, we have the 3 different motions actually that have to be completed in this case.
Yes, ma'am. The first motion is whether or not the educator violated the code of ethics, and if so, which standards, which in this case, it was 1 and 2, the inappropriate relationship and the professionalism. And then the second is to modify or accept the sanction. And then the third is to accept or modify the rationale, or give your own rationale.
Board members, any questions on how the motions are made?
I move for a finding that the educator violated the Code of Ethics, Sections 1 and 2.
Second.
There's a motion by Mr. Wood and a second by Ms. Rollins, a violation of standards 1 and 2. Any questions? Okay, all in favor say aye.
Aye.
Any opposed? Motion passes.
Make another motion to modify the recommendation of the PLSB and change it to revocation of the license
Is that with a fine, a $500 fine?
with a $500 fine.
There's a motion by Mr. Wood. Is there a second?
I'll second.
A second by Ms. Woods. Questions or comments? All in favor say aye.
Aye.
Any opposed? Okay, motion passes. The third is the rationale.
Make another motion to accept the rationale of the PLSB.
Second.
There's a motion for the rationale, a second by Mr. Wood, a second by Ms. Woods. Questions or comments? All in favor say aye.
Aye.
Any opposed? Motion passes.
Thank you.
Ms. James, is this something that goes back, to PLSB so they can see the decision that we've made?
I know that a lot of our PLSB members watch the board meetings, but I try to keep them updated on if something gets pulled, what the ultimate outcome is. We have quite a bit of conversation about that so that they understand the state board's point of view on the same cases.
Okay.
Yes, ma'am.
Thank you.
Out of curiosity, when we revoke a license, how often do they also pay their fine? Or do we write that off at some point?
Individuals have been pretty good about paying their $500 fines, even if, like I said yesterday, we had someone that paid it when they were in prison. So people are good about paying their fines with the hopes of someday getting their license reinstated and also doing what the state board requests. So,
Right.
pretty good.
Thank you. So now we move on to action agenda number 6.
This is regarding Mr. Terrell Brown. This is another one that was on your consent agenda previously that you voted to pull for prior sanction or should have been a sanction. And Mr. Brown is here today in person. He does not have an attorney with him. And as you know, he will get to make his opening argument first. He has 10 minutes.
Thank you. Mr. Brown, I'll do the oath for you first.
Yes, ma'am.
Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may proceed.
Like she said, I don't have an attorney with me. I didn't know when we did they gave me my initial hearing. I appealed it, and then I went to the meeting here, and they gave me my other findings. I just accepted that, and then I got another email that this was happening. So, for the allegations in BB, I told them I responded to I was the ALE principal in BB, the Alternative Learning Education, and we had a young lady that was been in ALE since 6th grade, and our goal was to get her graduated. So my team was trying to do everything we could to get this girl graduated, supporting her. It was her senior year, ACT, trying to get her to ACT prep. We tried to get her to join some of the school athletic teams. I took her to soccer, softball, basketball to meet those coaches, wrestling. So that was my only goal with her. And she emailed me on school email. We never contacted or conversated on anything other than that. No personal email, no social media, no text messages. But I did respond to her emails, and some of those were after hours and on the weekends. She would email me. I remember one Friday night, she was supposed to take her ACT that morning, and she was like, "Oh my God, I'm not going." And I'm like, "Calm down, you're going, you got to go take your ACT." I think she may have sent one on my birthday or something, happy birthday, and I just responded. But I didn't initiate any of those conversations. And the way our ALE was set up in BB, I had 4 different physical locations, and they assigned me a vehicle but I had, you know, other teachers and paras that also shared that vehicle. So there was a couple of instances where she had to be at the school. I know she had to go to ACC prep, and I went and got her in my personal vehicle and took her to the high school and dropped her off, and then went back to my office for those. But those were the things I did at BB.
Thank you. Ms. James, you have 10 minutes and then we'll open up for questions.
Whitney James with the department. The educator in this case, Mr. Terrell Brown, is alleged to have received and responded to multiple inappropriate, unprofessional, and personal emails, some after school hours and at night after 8 o'clock with a student who was 17 years old. As Mr. Brown said, he was the principal of the ALE at the BB School District at the time, and this was one of his ALE students. The emails included the following statements, and I know this was in your packet. Please note that at no point did Mr. Brown stop the communication from the student or tell her that it was inappropriate. One email said, "Come see me now, I miss you." Another email says that she loves him. Student emails, "I'm so glad I met you, you will never understand. You give me a reason to go to school. I couldn't ask for anyone better to come into my life." Heart emoji. Another email, "I won't be able to text or email you and say, 'Come see me' anymore. You're going to be the first person I run to. I really don't want to graduate because I want to stay with you." He also texted her sweet dreams at 9:32 at night. The student said she missed him, and he says good morning and that he will come to the Cubs building. I believe that was just the name of a specific building. I don't think that acronym.
Those are K6.
Okay. I don't think the acronym stands for anything. The student says, "You're gonna cry and love me forever when I get your present finished." He responded with 4 heart emojis. The student says she is getting mad and he asks why. She tells him she's not on her meds. The student says, "You know you love me, Duck. I'm just the best. Do you hate me for real? Be for real. I know you just act like you like me, but you actually don't." He responds, "LOL, no, you're my favorite. But at work when I'm dealing with issues, I'm dealing with issues." The student responds, "Yes, now I got proof that I'm your fave." Mr. Brown, as he said, transported students in his personal vehicle. He also engaged in a game of smash or pass. I don't know if you're familiar with that. That is a game where I guess one person indicates to another, "Look at that person, would you smash, have sex with, or would you pass, not have sex with that person?" There was a game of this going on in Mr. Brown's class, and a student asked Mr. Brown, "Mr. Brown, smash or pass?" He responded, they were talking about somebody walking by, and Mr. Brown responded, "Is she grown?" The student said yes. His response was, "Smash." He testified at the evidentiary hearing that he did not know what the game meant at the time. My question to him was, then in what context would it make sense that you would ask if someone is grown if you don't know what that game means? This is not the first time Mr. Brown has had an inappropriate relationship with a student. When he worked at Malvern School District, Mr. Brown allowed a student to stay the night at his house on more than one occasion when no one else but Mr. Brown was present. He and the student had inappropriate conversations about sex. He allowed the student to sit on her bed while she was in her pajamas. And this is all in a witness statement that Mr. Brown signed off on, so these are undisputed facts. At the hearing in this matter, Mr. Brown claimed that his conduct was reported by a colleague because she was retaliating against him. The allegations in this case are not unsubstantiated. Everything that was alleged has been proven to be true. The emails were introduced. The video of the smash or pass game was played at the evidentiary hearing. The statement that Mr. Brown signed about what happened at Malvern was introduced. There is a preponderance of the evidence in this case that Mr. Brown violated the Code of Ethics for Arkansas educators. Thank you.
Thank you, Ms. James. Now we open it up for questions?
Yes.
Is that correct? Okay, we'll open it up for questions and we will ask questions of you, so you'll have time to speak. Thank you. Ms. Rollins, Mr. Wood, Ms. Hunter, Mr. Bragg, Ms. Woods.
Was the Malvern incident ever reported?
No, it was not, and I don't know why, but no, it was not. Not to my office.
I'm sure.
More questions? Mr. Henderson? I want to check for you again, just to see. Okay, not on right now. Okay, Mr. Brown, if you don't mind, would you share any details of why you think that case in Malvern wasn't submitted to PLSB at that point in time? Any mitigating factors around that?
Because it was just that. I mean, there wasn't anything founded because there was nothing to it. It was another ALE student. I was actually trying to help, trying to pour into her life, and her mother. I took them furniture. I took them money. I took her and her mom a TV. The young lady I was taking to church with me. I go to church in Sherwood, and I was taking her to church with me. I took her to my family. She had Easter dinner with me and my family, just trying to show her some normalcy, some middle class normalcy. But she started skipping school. And I kept telling her, hey, if you keep skipping school, I was a classroom teacher at that time. I wasn't an administrator, so I didn't, know all the stuff about fins and all that stuff. But I said, I'm gonna have to report that you keep skipping school. And she said, well, if you report that, I'm gonna get you in trouble. And then that next day, that's when she came up with all these allegations. And the smash or pass game that Miss James refers to, I wasn't a classroom teacher, and I was an administrator, and I had all the kids 7 through 12 they were eating lunch. And I was on my computer, I had my teachers just go take your lunch. We didn't have any paras that day. So they were playing this game in the background, and I was on my computer, and they said, hey, Coach Brown, smash or pass? And I was like, what are you talking about? Smash or pass? And I was like, is it a grown person? Yeah, and I said smash. They all laughed. I didn't know one of them was recording, and that was it with that game.
Do you feel that you've crossed the line with these students? Do you feel like you crossed the line with these students in these situations? What is your reflection on these
definitely
situations?
Responding to the emails after hours and on weekends was definitely crossing the line. Put them in my vehicle. I know that. But in those moments, like the young lady texted me, I'm not going to take my ACT. I felt like I had to respond. I know it was an ethics violation. I'm not naive, but it's like, you've got to go take that test. And then getting her to the ACT prep, she missed the deadline. Her mom I texted her mom, and her mom allowed me to sign the consent form to get her to that ACT prep. So, and she had to go at that time. We didn't have a vehicle, so I went and got her in my vehicle and took her to that.
You've been here today and heard the cases going on. I want to show that our board has a very hard line for how teachers interact with students. Do you wish to work in a public school again? And
yes,
if so, what do you think what would you do differently to not even put yourself in situations for something like this to happen?
Oh, everything totally different. I mean, communication, transportation, being transparent. If a student does contact me after hours, letting them and the parent know, hey, this is inappropriate. I will not respond, and you should not reach out to contact me after hours. The one she had mentioned about, seeing her in the morning, we had gotten her down to a half a day. She had 3 credits to make up. That's why she said, I don't want to graduate, because we were trying to graduate her early, which she did graduate in December of last year. But to keep her at school, we let her volunteer in our Cubs because the little kids loved her. So she would go over there half a day, and then she would be in our hybrid location working on her schoolwork the other half of the day.
I have some questions for Ms. James. Thank you. Ms. James, who was this submitted by? The PLSB case, or is that anonymous?
I believe it was submitted by the director of HR at BB.
Okay. And was the student interviewed?
Sometimes we don't interview students. On this one, we had voluminous emails, and the district had spoken with the student, and we also had the video. And then for the Malvern case, we had, of course, we found out about it as part of this investigation, so we didn't go back and interview that student, but we did have Mr. Brown said that those allegations were unfounded, but he admitted the student stayed the night at his house without others present. They talked about sex. She sat on his bed with her pajamas on after she took her shower and talked with him. So there was quite a bit of evidence that was not disputed about what happened with students.
Okay, so then, I mean, this is our continuous conversation. What, was any of that submitted to DHS for child maltreatment? And if so, what did those conversations look like?
Yes, in the first case, it was submitted to DHS, and I believe it was found unsubstantiated. I'm not sure exactly why. The student did allege that there was a sexual relationship, and the outcome of the DHS investigation was that there was not a true finding.
Okay. And then what about for the second one?
No, ma'am. I
Because the
don't
level-
believe it was submitted to DHS.
Because
I
of
don't.
the level of severity, or
Um,
I mean, did it
I'm
rise
not
to
sure
the
if
level
it
of
rose to the level that they would need to report, but I don't believe it was reported. It was emails, using the school email system, and I believe when he did transport her on campus, there wasn't anything outside of school or text messages. Maybe it didn't rise to the level. There were just voluminous text messages from the student to Mr. Brown that he, yeah, thank you. Emails from the student to Mr. Brown that he did not put a stop to.
Which case are you talking about right there?
The second one, the one that was reported to us.
Do you have any, so remind me the time frame for that email exchange, and do you have an idea of how many emails there were? You've read to us some of the
Mhm.
content of the emails, correct?
There were, may I ask my investigator to come up and help me with these things? Hundreds of emails.
Yeah, I believe there were 600 emails.
over what time period?
Over basically the fall semester of last year.
But not all of those were inappropriate, or what we're considering to be inappropriate. I mean,
They were, not all of them were, they
Okay.
were basically unprofessional. They were not school-related emails. They were not school-related communication.
They were not all emails about graduation and ACT.
Make sure you speak, they can't hear you online.
Okay.
If you don't speak, both of you.
And so then, to what extent do you all do further investigation?
In this case, the student had told a teacher, in the BB case, that Mr. Brown had told her that if anyone found out about their emails, their communication, that he would be in trouble because he had been in trouble for that before. And so when I heard that from the HR director at BB, then I then started looking at other places where he had worked. And on the second call to a school for where he had worked, I discovered that that was where it was, at Malvern.
Board members' questions? Mr. Bragg, Ms. Woods, Ms. McCaskill,
still thinking. So.
Ms. Rollins, Mr. Wood.
Are we allowed to question on the Malvern incident in this hearing, or no?
I mean, we can answer the questions that we can answer, but it was part of the evidence at the evidentiary
No, but I mean,
hearing.
like, could we ask Mr. Brown?
Oh, yes,
Okay.
ma'am.
I
Yes,
just didn't
ma'am.
want to go outside of the purview of what we
Yes,
were
ma'am.
allowed to. So the Malvern incident, did you have someone spend the night at your house by yourself?
Yes, ma'am. We had left Easter from my parents' house in Jacksonville, and it was late, so we just stopped at my house. I was living in Benton at the time.
So you had an underage child at your house by yourself?
Yes, ma'am.
more questions, board members?
I would be curious as to whether there should be any accountability for the administrators at Malvern for not reporting that incident. I don't know what their mandatory reporting requirements are when it comes to PLSB issues as opposed to child maltreatment issues, but I'm offended that they did not find that concerning. I hope the department will inquire into whether someone in Malvern should be held accountable. I'd be prepared to make a motion if the board is.
Board members,
interested.
any questions or comments?
Can we just know what was the original, when it was on consent, what was the original sanction?
It was, let me find that just real quick. It was suspension of license followed by probation. Let me find the 1 year, yes, 1 year suspension, 2 year probation, $400 fine, coursework, readings, written reflections, quarterly reports.
And did it undergo an evidentiary hearing?
It did. They upheld it. It was the same. The sanction was upheld at the evidentiary hearing.
Okay, thank you.
But the rationale was only based on that hearing and not from Malvern? Because there was nothing from Malvern.
So at the evidentiary hearing, the Malvern incident was brought up, and part of the rationale was educator has a pattern of similar behavior at the evidentiary hearing, yes.
You can make the motion. I think based on our last conversation we just had, I think the appropriate response is revocation. I'll make that motion, to see, I mean, that's consistent. I think there's a line. You don't have an underage child at your house when you're in a position of authority over them.
Would you want to, I'm so
No,
sorry.
no, please.
Would you want to make the motion that there was a violation of Code of Ethics, Standards 1 and 2?
Yeah, we have to have the three
Yes,
motions.
yes, we're back to that, yes.
Any further questions? Okay, and the floor is open for motions, the first one being on the standards.
So I motioned for that, so there was, that we find a violation of Standards 1 and 2 or uphold.
Second.
Okay, so there's a motion by Ms. Woods, a second by Mr. Wood. Any questions on the motion? Okay, and I'm just checking. I will note for the record that Mr. Henderson is not on, so he's not voting on these. Okay, so motion on the floor. All in favor say aye.
Aye.
Any opposed? Motion passes. Second motion is in regard to the sanction.
So I would motion that we modify the evidentiary hearing for a revocation at $500 fine.
There's a motion by Ms. Woods
Second.
and a second by Mr. Wood. Questions or comments, board members? Okay, all in favor say aye.
Aye.
Any opposed? Okay, motion passes. And then the third statement is the rationale.
Yes. Would you like for me to read the rationale from the evidentiary hearing panel?
would.
Okay. That rationale was inappropriate communication with a student in parentheses S, with no educational purpose, negative impact on student based on what the student told other educators. Educator has a pattern of similar behavior. Educator admitted that actions were inappropriate, violated multiple school policies.
Okay, so that's the rationale, and so there's a motion to accept or modify, or create your own.
Somebody feel free to wordsmith it. I think we need to have in there something similar to what we had in the previous case. Basically that they had a student over unsupervised, whatever the language was in that last one. Feel free to wordsmith it how you do, Jeff, but.
Let me find it.
Because that's my rationale for my motion.
Educator acknowledged that the student spent the night at her home. That was after consuming alcohol.
I would just say that educator acknowledged that a student spent the night at his home.
Alone.
Alone.
So you're adding to the original?
Yes.
Okay. So your motion is to add to the original?
Could you read it again with the modification, just so that
Sure.
Thank you.
Inappropriate communication with students with no educational purpose, negative impact on student based on what the student told other educators. Educator has a pattern of similar behavior. Educator admitted that actions were inappropriate, violated multiple school policies. Educator acknowledged that student spent the night at his home alone.
Yes. And I'll motion for that.
A motion for rationale by Ms. Woods. Is there a second?
Second.
A second by Mr. Wood. All in favor say aye.
Aye.
Any opposed? Motion passes.
Thank you.
Thank you. That's the end of our cases for today.
Yes, ma'am.
I do think that it will be important for you all to have those conversations with the PLSB board as far as where we stand and where, we provide that last leg of public accountability.
Okay. Yes, ma'am.
Thank you.
For the record, I'm not offended that the PLSB makes the recommendations they do, and then we review them and go even stronger. I can appreciate that, given that so many are approved in a consent agenda, that we're not consent agendaing a ton of revocations of licenses. I kind of like that. As much as I hate this process, I think that it defers the most due process to the teachers. And so I appreciate the hard work that the PLSB does. I hope they feel supported, that, serious sanctions should result from egregious behavior.
I think
So-
the one thing though, with that in mind though, because we have these cases on the consent agenda, we have to really thoroughly review them. And I've always realized that we're the only consistent body that's seeing them, because the PLSB is great people volunteering their time, but you're gonna have different groupings of people, correct? At different points in time.
The ethics subcommittee is the same group each time.
Oh, it is, okay.
Yes, the evidentiary hearing panel is a pool.
Okay, it's evidentiary,
That
okay.
way, we're not handpicking who is on the panel.
Yeah.
So it does vary. We may have more administrators one time, more teachers one time.
Yeah.
It really, we try
Okay,
to
but-
make sure it's a fair sampling of,
But as far as the subcommittee goes, it is going to be the same individuals looking at every cases.
it's the same.
Okay.
And as long as we have a quorum, there are some that can't be at every meeting, but it's the same 5 that are on that subcommittee each time, unless we have a membership change for some reason, but it's, yes.
I would add that probably a little bit of frustration before today, but today may have caused that to multiply several times, my frustration at DHS and the extremely seemingly inconsistent application of whatever standard they apply, if they even have one. And I can't tell if my frustration is that they put people on the list or that they keep people off. I don't even know which one I'm frustrated with, but that's frustrating in itself. It almost leads me to give no credence to what their process is, almost like we shouldn't even discuss it. We should just have our own finding of fact, because it just feels so unreliable. Maybe I shouldn't say that, I don't know,
No,
but.
I think also to that, the litigation that ensues, I don't always understand of when it's turned over to the local
Mhm.
prosecutors and when it isn't, and how they determine what should be a case or not. And I guess at the end of the day, we are all 3 different accountability bodies. And
Yeah.
while we just have jurisdiction over their license, that's important, in protecting students.
Prosecuting attorneys are elected individuals and answer to the public and are usually very good guardians of justice. And I give a lot of deference to them. That can be messed up, but I can't figure out the DHS stuff, and I don't know how the opposite directions they went on the things that we saw today. I can't square that round peg.
And so to me, today, the cases kind of ensued on how much a student would testify too, which is hard. And then I think one thing that I took away from yesterday was the inability to really fully pursue everything. I mean, y'all don't have subpoena power to look at every text message or every Snapchat or all of the social media. And so we don't always have the full story, perhaps, of what's going on.
But interestingly, we do have subpoena power.
Our board does?
Our board does.
Yeah.
And so if we felt it was necessary to obtain more evidence of something, I believe that we would probably have the authority to subpoena individuals to bring documents before us.
That is a good point to keep
It's
in
a
mind.
thought.
Okay. Well, thank you all. Thank you, Whitney, and pass along to your team. We appreciate the work that you all do. So many amazing educators out there, and it's unfortunate when we see problems, that we're glad you all find those so that everyone can remain safe and well. We will move along to item number 8, the Education Service Cooperative's annual reports. And we do appreciate, I know some co-ops are online, and those that joined us yesterday to answer questions.
Yeah, we did, and in the workshop yesterday, I think we had several co-op directors who came and was kind of able to talk about some of the actions and works. These are the annual reports that are submitted to the department every single year. There is a list of things in rule that have to be in these annual reports, and that's what's within these. And so at this time, I'll ask the board to make a motion to accept the annual reports.
Questions, board members? To my left, Ms. Rollins. Mr.
It's not a question about the report themselves, but it is a question about Arch Ford and the employees on staff there. I've read criticism and I've heard criticism that I think is fair, that has piqued my interest about why are there people employed by a co-op and employed at the same time by organizations like the AAEA?
We'd have to look at a specific employee. I'm not sure.
Yeah.
I mean, I'm not sure which employee we're talking about or what their role is.
I got you. Are they on? Is Arch Ford available to answer questions?
Is Mr. Taylor on? Do we know? I don't see them on there. They have a brand new director, which his name is Mark Taylor. Greg Grant was the previous director, and so I can follow up on that and find out which specific employee would be.
I would ask the question of all of them that are dually employed.
You might have someone that's under a mentoring grant that's getting paid. For example, maybe they're getting a mentoring grant for superintendent mentoring or something like that, or beginning administrative mentoring that runs through AA as well. I'm not sure. I'd have to go back and look.
Yeah, I got you. I just, when I read this, I can see a pretty glaring conflict of interest between the two organizations at times. Certainly there are times when their interests are aligned, but there does come a point where interests deviate, and I just wonder how they square that to dually employ the same individuals. I would love to get a straight answer.
Yeah, I can reach out to Mr. Taylor and ask if they have any employees that are also employed at AAEA.
Yeah, thanks.
Questions on the co-op reports? Mr. McCaslin, any questions? So as you all said yesterday, this is an annual report that they submit. You all just finished your evaluation process last year.
Last year.
How
It's
often?
once every 5 years, currently outlined in rule.
Okay. And we talked about yesterday the inclusion of student data within these reports, or some sort of legislation requiring more student data reporting. Is that something we'll see in future years, or is that a
Yeah, I mean,
separate
absolutely.
report?
That's something that we can put as a request in next year.
Okay. Okay, any more comments or questions, board members? Okay. then board
And as we
members-
talked about yesterday with that data part, they are doing student data conversations now at their board meetings too, so.
Floor is open for a motion. And this is to approve or not approve the,
I'll make a motion to approve the annual reports from the co-ops.
there's a motion by Ms. Rollins to approve. Is there a second?
Could I just clarify, is it to approve or to accept?
Ooh, good question.
You can accept them.
No.
Okay.
Yeah, I would prefer to vote to accept them. If that's okay.
We'll change my motion to say accept.
Thank you. Thank you. So a motion to accept the reports by Ms. Rollins. Is there a second?
I'll second that.
A second by Mr. Wood. Any questions? Okay, all in favor, say aye.
Aye.
Any opposed? Motion passes. We will take, that is, wait, okay, let's stop. That is the end of our action agenda item. Let's do the consent agenda. We'll take a 2 or 3 minute break to let Miranda pack up. And then I think we have a number of individuals who've been waiting for public comment. So perhaps do public comment and then hear reports.
Sure.
Yeah, if that's okay with you all. Well, let's do the consent agenda now. So we have a consent agenda in front of us. Does anyone have any questions or want to pull any items from the consent agenda?
I would like to pull, in light of all the things today, 6.5 with James Wilson to place back on the action agenda.
Okay, so that's item number 5. Yes. A PLSB case to be heard.
What is the rationale? for that?
Rationale. We received an email yesterday concerning more information than we had, obviously, in our consent packet. And so I would just like to review, I would like the board to review those messages between the educator and come to their determination on whether they thought they were sexual in nature or not.
And you understand that if we have a review, you wouldn't be able to consider the email that you received. We'd just be asking questions about the case.
Correct.
Okay.
Yes.
Okay, so the rationale is to review the text messages?
Well, the rationale is just to, can we get the educator here? If we pull it to the action, will he be extended an invitation?
I'll send him a notice.
Okay.
It'll be up to him if he attends.
Okay. But
So-
the rationale is just that we review his case as an action board
Okay.
based on the summary that you sent to us.
Review case. Okay. Got it. Thank you.
Board members, any other questions on, or items to pull on the consent agenda? Okay, with that, the floor is open for a motion.
Move to approve the consent agenda
Okay, without item,
without item 6.5.
thank you. So there's a motion by Mr. Wood. Is there a second?
A second.
A second by Mr. Bragg. All in favor say aye.
Aye.
Any opposed? Okay, motion passes. Let's take 2 minutes now. We'll let Miranda pack up and then we will do public comment. public comments? Well, I should have reviewed these. Each public comment is 3 minutes. And we have a new timer up here. At the end of public comment, we are not allowed to engage in questions. It truly is a public comment period. And today we have 6 or 7 individuals that signed up. First is last name Edwards. I apologize. I cannot read the first name well.
Somebody else has started writing and scribbled my name on it.
Okay. I apologize about that. Thank you for coming in, and thank you all for your patience in getting through our meeting to get to public comment.
Thank you. And I thank you all for letting us have the time to hear our voices. It's been a struggle to have that done, so I do appreciate each and every one of you. My name is Angie Edwards, and I'm here to request change for Quitman School. On May 15th of this year, I was made aware of my son and others being a target of bullying, humiliation, and sexual abuse, hazing, among other things, in the Quitman football locker room. The next day, my husband, my son, and I met with the principal, Mr. Stacks, and the head coach, Mr. Mars, where we were promised action would be taken, and it hasn't. After more than a week had passed, and I had not been contacted by anyone regarding the abuse, I myself made the report. I made the call to the hotline. From then on, all reporting was done by the victims' families. We have still not had one phone call from Mr. Stacks or Mr. Mars. Quitman School is a mandated reporting facility. This means coaches and principals are required to immediately report any kind of abuse. It is not their job to do an investigation and decide if it should be reported. There are many statutes stating these requirements that the state and those in authority have chosen not to follow. I request that this is looked into with the utmost diligence, as frustration of things getting swept under the rug. Meanwhile, children continue to be abused. Football players spent a lot of free time in the locker room unsupervised. Coaches are down a small hallway, but supposedly can hear anything that they need to. If they were listening, they would have heard my son's screams. My son is 90 pounds, maybe 5 foot tall, while a 6 foot, 170-pound teammate held him down. Another child, I call them children, held his face so that his mouth was open, while yet another teammate put his crotch in his face. The screams of my son, I believe, were heard, but were ignored because this behavior is condoned and encouraged by coaches. Somewhere it got started that bullying, humiliation, and stripping the kids of their dignity as a form of passage would somehow make them better players. This lack of supervision in the locker room is unacceptable and would not be tolerated in any other classroom. Hazing is out of control and has become a sexual perversion that, if was done by an adult, would result in jail time. I request a change. If I could demand a change, I would. But I am requesting a change to require coaches to be a presence in the locker room of some kind, and maybe even audio surveillance to help this from happening anymore. I also request that hazing practices be taken seriously and a severe punishment to save all of our kids from having this done any further. Thank you.
Thank you, Ms. Edwards. Stephanie White.
Before I start speaking, I did write our school 2 letters to the school board, and everyone had shut me out. No one has tried to listen at all, and I have a copy of those if you would like them.
Thank you.
My son was hurt, humiliated, traumatized, and violated during junior high football at Quitman Public Schools. The principal, Mr. Stacks, and the head coach, DJ Mars, and the SRO, Mandy Love, have gone out of their way to neglect the safety of children in this school. 4 parents reported the physical and sexual abuse happening in the locker room. I was told they would take this very seriously, that they would take our children to the safety center for a full investigation and questioning, and none of this ever happened. Instead of reporting as mandated, they decided to conduct their own investigation and choose to support the deviants and let them harm continue. I went to the school board meeting, tried to communicate. They wouldn't take my letters. The principal of the school board, Julie Varvel, spun around with her finger in my face and told me if I didn't like it, I could go somewhere else. And I said, what would you do if it was your kids? And she said, my kids are fighters. My child should never have to physically fight to defend himself or others, but he did many times in that locker room. He was fighting older boys that would say, all right, it's your turn now, like this was an initiation to big boy football. The abuse consisted of being bull-whipped, sometimes with the whip and sometimes just the stick of the whip. Shot at close range with BB guns and Orbeez guns, told to run from one campus to the football field, and then ambushed with hundreds of bullets once in the locker room. His head slammed into lockers 7 times the last day he went. He was held down sexually and humped. They've ripped him out of his locker, humping him from behind. There's video of Cash being held down, of what Angie shared earlier. 4 boys have pled guilty to assault, battery, and harassment. 1 pled no contest and was charged the same. The last boy is scheduled for October. His order states that he is not to be around co-defendants or victims until after his court appearance. He is currently playing quarterback for junior high football at Quitman. 3 of the boys have testified that this abuse and harassment happened to them in the past. The lack of supervision has allowed this to happen under the athletic director and head coach. We will never know the impact that this has had on their physical and mental health. This principal has been at every court date supporting the assaulters and their families. He put his hands over his ears and mumbled while his mothers gave our victim impact statements. The administration found a loophole in the no contact orders made by the judge to continue playing football instead of standing up for the abused children. These boys have been convicted of serious crimes in court, but placed on a pedestal as football stars at Quitman Public Schools. Eli has gone through horrible trauma and violence. He has been assaulted in a place that was supposed to be safe. He has been made fearful of a team and a sport he has loved. He's been put in situations a child should never be put in, and at the end of the day, he's had no one in authority stand up for him or any other child on that team. He did not return to school this year. Your intervention is vital for Quitman School District. Students for generations will be impacted by your decisions today. Mr. Stacks is the principal, the athletic director, and the assistant superintendent. He will be the next superintendent when Mr. Truxler retires in the next year. He is one man with all the power in the school. He could have taken care of this horrific situation. He could have protected these boys and others. He could have set a precedent of safety above all for the entire district. Unfortunately, he has chosen to use his power and influence to go out of his way to deny it, cover it up, and protect the assaulters. He brought the coaches, the superintendent, and the local school board right along with him. We need leadership who will take care of our children. We need accountability for those who are supposed to protect and teach and lead them. We taught our children to trust these men. We teach our children to ask for help and seek authority when someone is hurting or wronging them. Our children have been ignored, threatened, bullied, and laughed at. Our boys have been hurt beyond our understanding. They have stood up for themselves and their teammates. They are walking in a fire against teenage predators and adults who encourage them. We are walking in that fire with them, and we ask that you will too. Show them that wrongdoing comes with consequences, that there's a school system who does care for them above all else. Show them that their lives have value, that their stories have meaning. Please protect them. One of the boys who pled guilty has come forward this year with his parents and reported it twice that I know of, that sexual abuse is still going on in the senior high locker room this year. But it has gotten worse. They are penetrating with fingers now to the new players. This has to stop. Please help these children who just want to play football without losing their innocence or worse, committing suicide or an act like something we've all seen in Georgia last week. My soul is broken. We are counting on you to please step in and help. Well, I would like to request the immediate removal of Michael Stacks and DJ Mars and stop all football-related sports until a full investigation and all threats of violence are removed. Safety for the children should be everyone's first priority. Every child in Quitman deserves a good life, good memories of football, and not harm created and coached by the adults who are supposed to protect them. Thank you for hearing me.
Thank you, Ms. White. All signed up to speak about Quitman. Next, we have Adi Allenbaugh.
Thank you for the opportunity. You guys know that I'm an advocate, and I've advocated for students all over the state for free. In my estimation, I think I have attended over 2,000 meetings for kids, and I've advocated for over 4,000 students statewide. Rarely do I come before you, and when I do, it's pretty bad. I will tell you, when these parents reached out to me on June the 14th, my world stood still. This is the most horrific thing that I've ever witnessed, and the response from the district is just as horrific. If these things had occurred in a home, any home, these children would be removed from that home, and the fact that this has been allowed to go on in a public school setting that we are all paying for makes me absolutely sick. When in the world did we go from a state that has moved the accountability from the shoulder of the bully to the back of the victim? The school has done the most to protect the perpetrators and not the victims, and this is wrong at every level. That's all I got to say. Thank you.
Thank you. Next, we have Melanie Fox signed up.
Good afternoon. As a former school board member, I know there is a chain, a process of where to go for help. And I've helped Ms. Allenbaugh and these parents try to follow that chain. But at every level, the adults have failed these people. And so that is the only reason we're here today, is because the prosecutor, the judge was good, the school, the police department have all failed these kids. And somebody needs to stand up and do right by them. So I would appreciate anything you all could do to help. I know you're limited, but we need to bring this to your attention because it continues to happen. There was a case in Huntsville where they had the same thing happen in the locker room. And we've got to put a stop to it. So, thank you.
Thank you.
Given the extreme nature of what we just heard, could we have a brief discussion about what can happen after today as far as this goes? What authority does the Department of Education have to immediately investigate the things we've heard today with regard to the adults that are involved in the allegations?
So one of the processes would be through our ethics complaints. So I think one step we would need to do is for our folks over here in teacher effectiveness that oversee that is to look to see if there were ethics complaints submitted.
Can that begin today?
Yeah.
I hope it will.
And I want to make sure that the parents know, Ms. Allenbaugh, and you guys have the ability you don't have to wait for the school to submit an ethics complaint against an educator. You have the right to be able to submit an ethics complaint. So if that's something that you're interested in making sure that you get filed, please make sure you see these two ladies over here. They'll make sure that you have the right links or paperwork or whatever it is that you need to be able to do that. And then from that would start our process for investigations on the licensure part.
I think, for the record, I do not presume guilt or conduct or anything. I do not adopt what has been said, but this is extremely heavy and concerning and the type of stuff that keeps me up at night. And I would like to give everyone the opportunity to quickly clear their name if need be. But I would also like every opportunity to move swiftly to remove any offending person from any classroom as soon as possible.
Along those lines too, we've heard 2 cases today where there are incidences in other school districts that weren't reported. And I know we talked about the new law that requires reporting of educators who are either doing themselves or allowing things under their watch. I think this is a continued conversation we need to have, if that hasn't not already been done, in going up to leadership in school districts where things that have happened that have not been reported.
You're brave moms, thank you.
Thank you for coming in today. Next on our public comment list, we have Mr. Julius Wright.
Good afternoon, Arkansas State Board members, Secretary Jacob Olivia, Dr. Sarah Moore, Chairperson, and all others present. I am a member of the NAACP Education Committee. Our chairperson, Dr. Ann Anderson Gregg, had a prearrangement appointment and asked for me to give the comments in her place. According to what she has written, she says she has hope that the Arkansas State Board of Education will follow the law and make sure that the 7 board members of the Pine Bluff School District will be elected at one time instead of allowing the present board members to be elected in staggered election. This is the only way that the Pine Bluff School District will be under local control. Presently, local control does not exist with the Pine Bluff School District, which the State Board of Education granted last September. Ann Anderson Gregg went to the courthouse June the 13th in Pine Bluff and was told, as well as given the paperwork to run for Zone 5. She went out and obtained the 20 registered voters for that zone. Not once but twice, due to the fact that the first paperwork they received was incorrect. She turned in her paperwork August the 13th and was sent a letter by the Jefferson County Clerk and given all her materials needed, and told that she had filed sufficient signatures in number and validity, and that she would be placed on the 2024 general election ballot. A few days later, she received a phone call from a voter registration clerk who informed her that the only board seat for election was Zone 6 and 7. After obtaining confirmation by the Superintendent Jennifer Barbary, she apologized for the inconveniences and told that her name would be removed from the 2024 election ballot. Moreover, the Pine Bluff School District has not had an election in 5 years due to the state board, state control, and only 2 board members will be elected, while Watson Chapel will have 3 board members up for election on November the 5th. I would like to thank each of you for the opportunity to share my story with you. Humbly submitted, Dr. Ann Anderson Gregg, concerned stakeholder of the Pine Bluff School District. Thank you.
Thank you, Mr. Wright. We also have Ms. Charlene Wright.
I'm trying to get through this, because after 41 years in education, I've gone through some things and I can relate with them as a parent of a son of 46 years of age, 40, and 43 years of age. My heart goes out to them. I'm gonna try to cut some of this short because I'm kind of broken. I am disheartened in that your board member, Jeff Woods, in order to make things right at the July board meeting, stated that an emergency board meeting could be held to allow the Pine Bluff School District to elect all 7 board members, according to Senate Bill 364 and Act 633. No action has been taken within the last 60 days. Presently, local control does not exist with the Pine Bluff School District with a state-appointed superintendent and a state-appointed limited board making decisions that was not given by the annex governance in December 2020. On June 13th in Pine Bluff, I was given a petition to sign up to run for Zone 7. I researched and found out that I needed at least 20, and I ran copies of the petition. I canvassed my zone and obtained at least 30 registered voters. I returned the petition and was told that I had been given the wrong petition on August the 9th. After being given the correct petition, I canvassed my zone again and returned the petitions with the registered signatures needed on August the 13th. I am deeply disheartened when I read in the Pine Bluff commercial that Watson Chapel School District will have an election of 3 board members in November the 5th, 2024. Pine Bluff School District is being discriminated, and I know you said don't say that, Mr. Woods. I feel that we are being discriminated again and that we are not being allowed an election for all 7 democratically elected board members. Now we're being discriminated that we're not being allowed 3 board members like Watson Chapel School District on November the 5th, 2024. In my press release, after filing to run as a candidate for Zone 7, my destined mentors and supports drives my passion to help students such as I, lacking resources and direction to seek Zone 7 position. As Thurgood Marshall states, equal means getting the same thing at the same time and in the same place. I feel that I have the perfect opportunity for me to serve as a Pine Bluff School District member to help our students and district to receive the same education at the same time as other students in the state of Arkansas. The lack of transparency in the Pine Bluff School District has led to a limited local control with the appointed superintendent from the state and an appointed limited board. I feel my strengths of willingness to serve, resilience, integrity, greatness, highly qualified certifications, and experiences of 41 years as an educator and administrator. And my transparency will help the Pine Bluff School District to maintain local control of the Pine Bluff School District through academic success, fiscal stability, and equal opportunities for our Pine Bluff School District students, community, and district as an elected board member. Thank you as always for allowing me to have public comment, and I one day want to be able to stand here and say, you did it right. According to Act 364 and Senate Bill 364 and Act 633. I know we make mistakes, but I feel that we should have the integrity to correct those mistakes. Nowhere has staggered elections been done in Arkansas to any other district. All 7 electors were elected after the return to state control. How can you sit there, Chapel, and elect 3 and tell us we will elect 2? Somewhere it's gonna have to be righted. Somewhere. Hopefully, as Mr. Wood said, he was man enough to say, I was not for it in September of 2023. I feel that we should have an emergency meeting. I think it was you, Dr. Moore, said it only takes 3. Somewhere you have to say it's not right.
Thank you, Ms. Wright. Andres, was there anyone else that signed up for public comment? Okay, there's no one on the list. Okay. Thank you all again for coming in today, and we'll be following up as we know more. Okay, with that, we're on to the report section. Okay. So in our report section, the first report is the Prairie Grove Lincoln School District.
I'm sorry, can I ask one more thing about the things we heard a minute ago? Is it within the authority of the board or the department to act in an emergency nature to remove someone from the classroom pending an investigation? Is that a possibility?
I would have to defer to the legal team, and that might, I'm not sure if they need to have a moment to process that before. I don't have an answer for that.
Yeah, I mean, I don't want to give you a wrong answer. So for sure, we'll look into it, pull the statutes, make sure we're all on the same page, and then make sure you get that answer promptly.
If that authority exists, and if that authority were to require board action, and I don't know that it does, I have no idea. I would be more than welcome to have a special meeting as soon as possible to move in that direction so that we can make sure that the students are safe and individuals are given the appropriate due process, and we make good decisions, but with student safety being the most important thing.
Yeah, certainly. Right after this meeting, we'll start rolling the statutes for you.
Thank you very much.
Yeah, of course.
And Mr. Wood, I'm gonna go ahead and pull them out so we can get started on allegation.
Thank you.
I will just say for the code of ethics, since the educator is entitled to due process, that's not a quick fix, but we can get started on it. We aren't authorized to investigate anything, of course, until it goes to our ethics subcommittee. And due to confidentiality, I can't disclose whether or not we have any complaints regarding any of the educators that are mentioned, but the first step is filing the allegation, and Ms. Carly Saraceni is working on that right now.
Thank you very much.
I think lastly, I would be interested, I don't understand regulations around sports and adults and all that. And what the protocols are.
Yeah, but there are definitely professional ethics standards that can be linked, right? And so I think as Ms. Saraceni works with the parents, or, you know, they have to link them to a standards violation for this investigation. I think what the Department of Education's role and responsibility is for school safety, what the department's responsibility is for licensures of teachers. I mean, I definitely think there is a role, and there's definitely an actionable piece here. We just want to make sure our team is following the procedures correctly, and that we act. But student safety, you've heard Secretary Oliva say it over and over and over again, is paramount. So we will follow up.
Thank you. Thank you, Ms. Wilson. So, on to the reports from the Prairie Grove Lincoln School District.
That's correct, Chair and members of the committee, of the board, I should say. I'm just going to give you a quick timeline because I know it's been some time since, I believe, the June meeting when you first heard this petition. On June 13th, you originally heard the petition filed by Prairie Grove School District to change the boundaries and annex certain property on Kelly Mountain Road between the Prairie Grove and Lincoln school districts. At that time, he directed both the school districts to work something out to ensure that the students within that community would get transportation that would be something within an acceptable timeline. The school districts at that time worked together to put together an MOU That MOU was submitted to the department to look at on July 9th. And at the July board meeting, I at this point let you know that is the progress of that item. On July 11th, that was the July meeting. On July 16th, the Lincoln School Board rejected the MOU, and on July 30th, the Prairie Grove School District Board accepted the MOU. We have been notified by Prairie Grove that both school districts are working on something again to try to get to some form of agreement so that at that point they could withdraw the petition. Both superintendents should be available to answer any questions that you may have, and in terms of process, I'm also available to answer those questions.
Okay, thank you. I believe I saw Superintendent Spears from Lincoln.
On, but I don't see her now.
They're on the northwest, in that corner, and they're still on mute.
They're on mute. Both
Oh.
superintendents are actually together at a conference, so.
There we go. Okay, thank you all. If you don't mind getting off mute so we can hear you. Thank you. I'd seen you earlier.
You're good, right there. Can you all hear us?
Yes, we can. Can you hear us okay?
Yes, ma'am. Thank you.
Thank you. So if one of you would like to proceed with an update as to where this decision is sitting right now.
We can't. I'm sorry, we can't hear if you ask us a question. Sorry.
Okay, we would like to hear an update on the boundary petition.
We, as mentioned in the opening statement, we actually sent a proposal to Lincoln regarding the MOU that would essentially cut all the red carpet on for the kids up on Kelly Mountain, the 18 parcels, where if they wanted to go to Prairie Grove, they could go to Prairie Grove. If they wanted to go to Lincoln, they could go to Lincoln. We would keep the same tax dollars, no changes on boundaries. And, but obviously the funding from students would go, and Prairie Grove School Board adopted that, and the Lincoln School Board rejected. Lincoln called last week, and we have started a new round of conversations about how we can move forward.
Okay. At this point in time, are you all providing transportation for those students?
We cannot hear you. Sorry, we're not getting any of that.
Okay. Can you hear us at all?
Yes, now.
Okay. Can you give us an update on the transportation for these students in the schools that they're currently enrolled in?
Yes, ma'am. We are currently providing transportation for the kids that are going to Prairie Grove on Kelly Mountain.
Okay.
And that was MOU as well. Not typically what we do, but we are moving forward and providing transportation anyway.
Okay. Board member, I'm going to ask if other board members have questions. To my left.
So please forgive my ignorance, and I don't know why I don't know what's going on, but what exactly was the proposal?
The proposal for the MOU?
Yes.
It was just, there was no requirements for filling out any paperwork. All the students that are located on top of the mountain, in those locations that have been identified, would be able to choose Lincoln or Prairie Grove. That was the MOU.
Yeah, I've got the MOU. I just couldn't figure out what it said, because it kind of seems to me like it doesn't say anything.
Yeah, it's pretty simple. It was just a way that they didn't have to fill out any paperwork or meet any timelines as required by law.
So this is essentially a proposal for the districts to agree that the school choice deadlines don't apply.
I didn't hear the last part, I'm sorry.
Basically, it was a proposed agreement between the districts that the school choice laws of, declaring by May 1 every year that you're going to choice into another school district, those rules don't apply.
Yes, sir.
And then the Prairie Grove receiving students, right? Yes. So Prairie Grove, and I apologize, man. What I remember from our last conversation about this 3 or 4 months ago was that there was this obvious solution where Prairie Grove would just drive a school bus down the road for 1 mile, picking up a few more students, and then take them to school. And Lincoln would allow that school bus to drive down the road, and everyone would just move on about life.
If I remember, 'cause
Yeah.
I've driven
Yes,
this.
that's correct. I'll speak to that. Yes, that's correct, because in Lincoln, we have 3 neighboring school districts, Prairie Grove, Cedarville, and Siloam to the north, and we do pick up students in all 3 of those districts. We go across lines, pick up students, and we don't worry about boundary changes and all of that. The Lincoln board just felt like that MOU wasn't necessary because we do have options for school choice and board-to-board transfers, and that would kind of just added a different layer, and that actually those folks on the mountain just didn't want to do extra paperwork. I've actually had a couple of those patrons reach out to me via email, and they weren't in favor of this MOU. They're really pushing for a boundary change. So then that's something that we've kind of come back to the table to possibly look at, a possible, I don't know, I hate to say it out loud, but maybe a possible swap in some boundaries, to kind of make it fair. But those haven't been floated out to our board. That's just something that's kind of come to the table really in the last week. So that's something we're looking into. Otherwise, I mean, Lincoln's going to oppose the boundary change without some kind of concession on our end.
Yeah, I guess I understand that a little bit.
So I think, I just want to make sure, half the road is Lincoln and the other side is Prairie Grove. I mean, I've driven it before, so they're wanting basically the whole street to be zoned into that district. But they're already driving a bus over there to pick up the kids.
Yeah, I mean, it's pretty rural. The area, between our 2 districts, there's, especially to the south, it's pretty rural, kind of hilly. I mean, we're having to we cross into their district to get some of our kids just because the roads are better or whatever, and I'm sure vice versa. And certainly the same for north of Siloam. I'm coming in from that direction every morning, and I'm passing a Siloam bus that's coming out of my district, out of my lines, and picking up kids. And that's what we do. Kids that have choice or transferred to us, we're going to pick them. We're going to provide their transportation. We're getting that foundation money. We're going to provide transportation.
Well, and I'm specifically from Bentonville, Rogers, so I drove over there the last time we had this discussion just because I wanted to see. So, I mean, I can understand it's not like easy terrain to get down.
Certainly. No.
It is not.
It is not. That's why we close a lot more for snow than most.
Thank you for taking that drive.
You're welcome.
Is this just an update?
It is just an update.
Yes.
We're not being asked to, okay.
No, we're,
Very good. I feel much better then.
Am I being too simplistic, but if you're picking up the kids anyway, what's the issue?
Well, there's still a petition before you, as has been tabled multiple times in a row. The purpose of putting them at this juncture within, just the comment section is to update you on the progress because you've had a lot of moving pieces with the MOU getting drafted, getting approved by one of the school districts, but rejected by the other. To your point, Prairie Grove's already providing services to the students in that community. There is a legitimate question to have about the tax revenues that come with those students. If Prairie Grove is providing those services and is already busing those students into their school district, the revenue from taxes from that community are still going to Lincoln. And it is my understanding, to the superintendent's point, that the families in that community still want a boundary change.
okay, that's fair. Good.
That is accurate.
More questions?
Mr. Campbell or Ms. Spears, any additional comments at this point?
No, ma'am, thank you.
Okay, thank you.
Thank you, Chair.
Thank you.
Board reports. Do any board members have reports or any updates to share at this point? To my left.
Wow.
Close that.
To my right. And we'll go on to my favorite board.
Yeah. I will say this, Kim, can you bring me the clicker when you get a chance? I will say this though, I was already honored into this position, but after a today like today, I'm even more honored to be the one that brings you good news, and I realize how important it is for us to share that good news.
Right.
Because I mean, it's 32,000 plus teachers in the state of Arkansas, and Secretary Oliva would know the exact numbers, but I don't. But there's so many good stories going across the state in education right now. We need to make sure that those stories are heard too. And just lots of respect to you all for having to make the hard decisions. And just glad to get to close out today with a day like today with the good news.
Do you have 6 hours of good news for us?
I do not. I did say I was going to hurry through it because it's such a long day, but I think.
Take your time.
There we go. There we go.
The rehab.
Well, get you an update on the process of choosing our 2025 A-Toy. We narrowed it down to 4 last month. This week we had 2 on-site visits of our 4 semifinalists, and they're just awesome educators. It's going to be a very, very hard decision. We'll have 2 more on-site visits next week, and then I believe the announcement will be made in October for the 2025 Arkansas Teacher of the Year. But just an awesome opportunity for us to be able to get in their classrooms and to see all the good things they're doing. You learn something new as a teacher every time you go in somebody else's classroom. That's what I really look forward to.
Who makes that final decision?
Not me. It's a team effort. Team effort. A tough one, though. I was blessed in the fact that I got to spend the first week of school close to home. The first couple of days stayed at DeQueen and helped Miss Fuel get our DQTV kids, our new kids, off to a great start. And we mentioned earlier about pathways to licensure and making it easier for somebody outside of the education world, kind of that non-traditional route like I took, to be able to work their way towards licensure. Ms. Fuel has a background that works perfect for what I teach in television production, video production. Sevier County doesn't have a lot of folks with that background move into that county very often. What started out was going to be just a regular sub-paid rate of pay per day at $100 because she had a BS. We worked through things. We realized that we could get her into the RPEP program, but realized now that something easier and even an easier route for her, or a more appropriate route, sorry, Miss Carly might get on to me for explaining it that way, would be to get her a provisional license and being able to add the technical permit to that provisional license. So she went from what started out in August as a sub rate of pay at $100 a day, let's say 195 school days. You can do the math on that. To a starting salary for a first-year teacher of $50,000 because she was able to take that pathway. And that's just an example of how the profession of teaching is being lifted in the state of Arkansas and how it's going to be attractive to those that are outside of education right now. And she's going to be great. She's also going to get a mentor from the co-op to work with her throughout the year. And regardless of where she's teaching next year, she's going to be a great educator. And my kids love her. Now, the one on the right side is what I believe every educator should have to be qualified to do at some point in their career, and that is to volunteer for primary car rider duty on the first week of school. If you want to see one of the best transformations that takes place all year, that is the car rider line during the first week of school. Another piece of good news at DeQueen happened during the first week. We opened up the DHS new agri-science facility, broke ground on that. Why that's such a big news, it not only opens up a new facility, it opens up a pathway for a group of students who that might not have been a possibility. I grew up in a time to where my family didn't have a farm, but that was always interesting to me, was the fact that FFA and ag kids were showing animals. Usually that opportunity is kind of confined to students whose family might already have land, have a farm. With the new ag facility, those kids will have a place to keep their show animals, and also it's an opportunity to introduce a new pathway to a group of students where that might not have been possible beforehand. And on my ATOR visits, I stayed close to home. The first one, I took a trip down to Mineral Springs. If you remember, Mineral Springs not too long ago was under state control, about 10 years ago. There's been a lot of progress at that school over the last 8 to 10 years. They have built a new school, lots of new facilities. Mr. Emerson is the new superintendent down there at the bottom, but the highlight of my day was running into two of my former students who are also now teachers. Quentin Thornton over on the right is a football coach who teaches geometry, and Jessica Williams over there on the left is, I taught both of them in civics and American government, but she is the softball coach at Mineral Springs and teaches biology. It was a great day at Mineral, and then of course I went down to Foreman where I got my start to teaching. Nice surprise there. Foreman is also a school in Southwest Arkansas that's built a new high school in recent years. I didn't realize this, but they decorated the hallways with every single graduating class from Foreman, the class portrait that they had. And I had not been inside the campus at Foreman since my last day of teaching there, but they pointed out the fact that my picture was still up on the wall from being a class sponsor to the senior class of 2010. So that was a real nice highlight of that trip. Mr. Matthews there on the right is also a first-year superintendent for Foreman Public Schools. He's off to a great start, and they showed me around to their CTE programs. Foreman's always had a very strong Agri program, and they also have a pretty strong business program. There on the right, the RCC logo, let me look at Rocky Comfort Custom Designs, I believe is the name of it. That is their student store, where their graphic design makes logos, and then they're able to sell their designs to the public. Made the trip up 71 to Mena Public Schools. On the day I arrived at Mena, Mena's a pilot, or is a member of the pilot program for the phone-free schools. And on the day, they're doing it a little bit different. They don't have the pouches, they have the lockers. And on the day I arrived, they were receiving their keys to their lockers. What stood out to me on my Mena trip, they're doing a lot of creative ways to promote literacy. And one of the cool ones is their Flashlight Fridays, where they turn the lights out and the kids get to read with their flashlights. They also have what they call celebrity read-alongs. By celebrity, I mean they're bringing in the principal or somebody from high school down to the lower grades to help with their read-alongs. And then the visit to Caddo that really stood out this month was to Caddo Hills Academy. Caddo Hills, they launched Caddo Hills Academy 2 years ago with the help of a $1.25 million grant from the Arkansas Public School Resource Center. It's really interesting, and I really encourage anyone to make the trip down there to see what they're doing at Caddo. They've really kind of flipped it to where they're really focusing on leadership within their school, but also how their CTE programs all work together. They're intertwined, and they're focused on not just turning out college-ready students, but also career-ready students. And several of their programs, their students can walk right out the door and get a job that day within their community. The manufacturing program is a great example of how you don't just have to have partnerships within your community, you can have partnerships within your region. This is their manufacturing and engineer program. The students actually do the coding that tells the computers, and this gets a little above my head, so I don't really want to get technical with it, but they're making metal parts, and they've partnered with a business there in Mena, as well as just outside of Caddo Valley around Hot Springs, where they're actually making metal parts for these companies. Their partner in Mena had actually contacted them that year. He says, hey, do you have anybody you can send me yet? I need these positions filled. He said, they're not ready quite yet, but at the end of this year, they will be ready. And those students will be able to walk in and fulfill those positions that are in need. They have 3 levels of graphic design, 3 levels of business, as well as 3 levels of banking. The graphic design students come up, much like what I was talking about at Foreman, they come up with the designs, they create the designs, and then hand those designs over to the business program, which operates Native Supply and Company. It's across the hall, it's a school store. Anybody can go in and buy those products as well. And right across from Native Supply, you'll see Indian Nation Bank. That is a bank right there on the school. It's student operated. And then let me make sure I get this right. I told her I would get it right. Miss Duncan, she actually stepped out of the banking world, was already working in the banking industry, stepped out of the banking world, had just finished her 2 years with the RPEP program, is now a certified teacher. And she said when these kids finish this program after 3 years, they can step right into the banking world there in Glenwood. And she's got all of those connections, which she has from her time in the banking world, where she can line them up with jobs. And then wrapped up the month, UA Cossatot. UA Cossatot's got 3 campuses. They've got a campus in DeQueen, in Nashville, as well as Ashdown. And then they have their little satellite operation in Locksburg, which really allows them to build lots of partnerships up with our area schools. They had the Be Pro, Be Proud event first week of September. They were there for 3 days. The Be Pro, Be Proud truck was, and the Be Pro, Be Proud truck, of course, that's one of Randy's proud tools. It introduces students to over 17 different jobs, careers that are high wage and high demand jobs. Not only that, we also had Holly Shader. She's one of the career coaches there in the middle. She was over the event. She also had lots of other local businesses on hand. And then, of course, we wrapped up the month of August with the Teacher Appreciation Night at the Arkansas Travelers. I got to throw out had the opportunity to throw out the first pitch, which is always fun, and happy to report it was a strike. I didn't skip it, which was my greatest fear, because there was a lot of folks back home that would not have let me hear the end of that if I did. But no, just a great night there at Dickey Stevens Park. Really appreciative of the Travelers having that night to honor the teachers each year. That's it.
Awesome.
Love that program at Caddo.
It's amazing.
Cool.
It's amazing how it all works together, and I really encourage you to make the trip down there sometime to see how they work. Justin Neal is the principal there, and he's got it going on.
Yeah.
Does a great job.
And I went to Mena Middle School, so
oh, yeah?
Thanks for having a picture of the Bearcats up there.
There you go.
Love Southwest Arkansas.
Yes. It's a good time. We Southwest Arkansas, we tend to have a bubble above us that keeps kind of all the negativity around us or from penetrating, but sometimes that bubble keeps the spotlight from being shined on us too, and that's kind of what I'm happy to be able to do here.
And I'm excited thinking about the teacher that took over your classroom, thinking about other individuals that you can help get on that pathway, so they can be particularly strong out of industry, banking or other areas in other districts. So excited for your platform as you would do your work this year.
Thank you.
Yeah. Any other comments or questions, board members? Thank you. With that, we will allow.
Yeah, just a few minutes. It's been a long day. It was an emotional and kind of draining day too. And Audie stepped out, but when she got emotional, I've known Audie for a long time, and she doesn't do that often. And Audie and I don't always agree, but there is a passion about what we believe about kids and what we want for kids in our state, right? And I think that all of us that are educators are sitting on this board, we want our kids to be safe in schools. In light of what happened in Georgia, school safety is the #1 thing for all of our schools. We used to say education was the #1 thing for all of our kids, a responsibility. But it is school safety. And we are really doubling down on what we expect from schools as far as providing a safe environment for the students in their schools. We've had numerous, if you've been watching the news, you're going to see news right now on different school threats that are happening. People mimicking a lot of online pieces, and so a lot of our school districts and superintendents and principals and teachers and parents are having to grapple with this. Is it a real threat or is it a fake threat? Is it somebody trying to get out of school, and what to do? Our school safety unit is providing direct support. We're providing direct support to schools out there, but just keep those folks in mind. It's hard to sometimes make those calls and decisions about what's going on, and no one will be satisfied with the decision that you make, whether you kept school open or you closed or you know, what you did. But what we want to make sure our schools know is that we're here to support them, and if they need something, we're here for them. I think this parallels the work that the governor's office is doing, especially around cell phones and the use of cell phones. We saw lots of schools who opted into the program of using the pouches. And again, that conversation about students with cell phones at schools, do they need them, do they not need them? Where do they need to be if there is an emergency situation? Secretary Lee will tell you that kids need to be paying attention to the adults if there's an emergency situation. And we feel like the pouches is a way to be able to do that. And so again, we're seeing that initiative and that program launching in our state and lots of schools participating. We think that there is a mental health crisis going on with our kids directly linked to that. And so again, thinking about safety for our kids and what that means not only as physical safety, but mental safety as well. School overall started successfully. Despite this day of all the cases that we've heard, we've had a great start to the school year. And we have lots of teachers and lots of kids who showed up excited. I've had the privilege of being in many buildings already and getting to see some really great things. And so I'm hopeful. I'm hopeful. We started this morning seeing the Russellville National Quiz Bowl team. Yeah. We got kids learning. We got kids competing. We got kids doing great things. And so I think sometimes we just, after a day like today, we forget, right? And so we have lots of good things continuing on. One last thing I do want to bring up is we did start, and I know some of you may have heard some feedback. We started our new assessment system, Atlas system, last year. We tested overall. But at the beginning of this year, we started the screening component for K2. That just launched this last week, okay? So we've had our team out in the field observing that screening tool being used with kindergartners, first graders for the first time. There are some tweaks that need to be made. It's not gonna be perfect this first rollout, but we've seen some really promising things. We've seen some things that are good. The exciting piece for me is when we get this right, which we will, is for us to be able to set a common cut score that indicates when a kid needs to move on to that level 2 screener or level 1 screening element of the testlet to help identify additional characteristics or more support that's needed, and we're gonna get consensus. And it's gonna be really clear about the expectations for students reading in this state. So that is exciting. It's not perfect. So if you get an email that says it was too long or kids had difficulty on this, know that we're working through those bumps. But it's going to be a state-of-the-art system, and we're going to be the first in the nation to be able to implement something like this. So it's exciting. Thank you.
Awesome. And with that, any additional comments or questions from board members? Then we will adjourn and close out. And see you all next month. Thank you so much. And thank you to all the staff that worked so hard to make our day run so smoothly. We appreciate you.